Court does call the case of Dale Gretsch versus Taylor Adams.
Good morning, Your Honor. Alex Barry Santoro appearing on behalf of Plaintiff Dale Gretsch and Dina Davis, P81545. Nice to see you.
Good seeing you, sir. And this is, I thought, defendant's objections to garnishment.
That's accurate, Your Honor. I did file a writ of garnishment, and there was an objection served after the 14 deadline to effectively stay the garnishment. So I'm here today to
Object to any stay of the garnishment. Right?
Yeah, that's the lawyer.
I'm brilliant. I figured that all out on my own.
Yeah.
And they're not here. Taylor Adams, Tiffany Gross.
Do you want me to call the hall or something?
Well, Adams, Gross.
No, I know them.
No. The defendant having failed to appear, the motion regarding the objections to the garnishment are denied. Garnishment may proceed. That denial is based not only on the defendant's failure to appear, but also on the merits of their objections.
Thank you, Your Honor. I appreciate your time.
Thank you, sir. Mediation versus Fatima Stevens.
Fatima Stevenson appearing on behalf of herself. Good morning.
Good morning, Your Honor. Jay McCurgy on behalf of Jing Mei Shin, P8321.
All right. And this is your motion for relief from judgment, ma'am?
That is correct.
All right. What do you want to tell me about it?
Counsel and I originally in late May, I believe, were discussing the option of me purchasing the home that I'm currently renting, because at that time I was made aware that the owner was intending to sell the home. So it would have benefited all parties if we were able to make this transaction occur. It has taken a little bit of time. We've all kind of, well, I can't say we've all, but counsel and I have corresponded through email, as you've seen. The property manager, who is also a realtor, and I and the realtor I had secured recently have also been in communications as of yesterday. I was just made aware late yesterday afternoon that the property manager who was in correspondence with my realtor and lender is not the listing agent. So therefore had no authorization this entire time to work on the deal. And so anyway, long story short, I had not looked for alternate living. I wasn't intending to seek alternate arrangements to move out because my intention was to actually purchase the property. It wasn't going to be a quick thing, but it was going to take a little time. But as long as I showed progress and all the relevant parties that were interested were kind of kept in the loop to showcase good faith that we could move forward with that and stay the eviction.
Thank you, Your Honor. The home is not currently for sale. Hasn't been listed yet. My client wants to get the property back.
But, okay, just so that I'm clear, the original is conditional order of dismissal.
Correct.
Was put into place with contemplation of a sale?
That is correct.
No, Your Honor. That is not the case. Stevenson is representing that we've been in discussion for sale of that home. That is not accurate.
Okay, but was there somebody on well, let me ask this. whether they had authorization or not. Was there somebody operating on plaintiff's behalf that was leading toward a sale?
So there was after the affidavit was sent in late June, Ms. Stevenson sent me this email that she has, I guess, attached to this motion here, that she's been approved for a mortgage.
Okay.
And as you can follow through this email chain here, essentially, she wanted to put together an offer, and I said, if you're going to do that, you might want to do it quick because we're running out of time here. And that's essentially where that conversation ended on my part.
Right, but there were also other individuals that
The
were,
text messages, Your Honor?
yeah, well, there are other individuals that are involved that are seeming to indicate that the purchase.
On the plaintiff's side, Your Honor, there is a realtor who's the property manager who had asked Ms. Stevenson for a pre-approval letter or something at some point. Nothing was provided. I have an email chain here that I can submit for the record. Let's call it and it clarifies what happened.
Clarifies. Well, okay, so here's what I'm getting at. There's someone on the plaintiff's side that is talking to somebody on the defendant's side regarding the sale. I'm a bit concerned because as I'm hearing you, the person on the plaintiff's side is a realtor, right?
That's correct.
There are, it seems to me, discussions that are going on regarding, between the person that's a realtor on the plaintiff's side and a realtor on the defendant's side.
So the person who's a realtor on the plaintiff's side has no agreement to sell the home. There's no.
I get the fact that there may not be some agreement between plaintiff and this person.
Okay, in no way does this person represent the plaintiff or their interests.
In some way they do, don't they?
So, Your Honor, I think the statement that this person is the property manager is incorrect because this person has told me they're not the property manager of the property.
Who are they then?
They
vis-a-vis the property.
They helped the homeowner purchase this home or find this home as a property for their portfolio.
Say that again?
They helped the homeowner find the home as a property for their portfolio. As an investment property, this property.
Okay. Okay.
Yeah.
If that's all they are, why are they entering into discussion?
Your Honor, I don't know. If we look through, I have an email from that person in an email chain that both Ms. Stevenson and I were included on from yesterday, and it describes an email between her realtor and this other person describing what.
This other person being whom?
The person's name is Kirk Glassel.
And that's the person that now you're saying is nothing regarding this property.
That's correct, Your Honor.
Then why are they involved in an email chain?
This email, so Ms. Stevenson, I would say, was speaking to a realtor. This realtor reached out to this person they believed to be the real estate agent for this property, although that wasn't the case. And they had a discussion of this email that both Ms. Stevenson and I were.
Close up and no, go ahead.
Yeah, this email that we were both a party to verifies what that discussion was, and that they, what they believe the intent of that discussion was.
If I could clarify one thing, Your Honor. In the email from counsel, it clearly states in the email that I had submitted with the motion, for the recommendation was for me to send the offer letter to this individual in particular, and then
This person who now is being claimed to be nothing.
Yep,
exactly.
that's,
I do have other.
Well, okay, but hold on, folks. This may make sense to you, it doesn't make sense to me. Why would she be sending an offer letter to somebody who really has no affiliation to the property?
oh, I was thinking he would communicate that offer to the home. Should there have been an offer? Because I'm not.
Then, right, but is, okay, Mr. McCurdy, that's part of my problem. Part of my problem is this person and your client may be saying they have nothing to do with the property. Apparently, the defendant believes they do and is operating with some apparent authority. And you yourself also may not know what that position is, but like you said, I'm not a realtor, but this person is doing something. And the very fact that the person is a realtor, I think that there certainly is the potential for some confusion regarding that. And I think that's part of my
I do have more recent communication as of yesterday with the same person,
with who?
with that same realtor, and yeah, and my realtor and the lender.
And the lender?
That's
So if Your Honor, if I
Go
can
ahead.
clarify, I have an email right here between all parties, just clarifying what has happened in an email. And the email includes her realtor, this email chain includes an email from her realtor, back and forth. I believe it's relevant.
Okay, but Mr. McCurdy, the very fact that all of this needs to be clarified, isn't that a problem?
So, Your Honor, after I spoke to Ms. Stevenson yesterday, she made it clear that she was gonna believe that she's been misled here. So I reached out to the realtor to see what was going on.
Right.
If she hasn't misled, if there was discussions with the loan officer, if there was discussions with a fellow realtor, and what he described to me was something close to what we're talking about here, but not, but missing the target by a little bit. He believes this was a last minute attempt to confuse the situation and stay the eviction. And he clarified that in an email because the realtor who reached out to him had not signed an agreement with Ms. Stevenson. It was just an informal discussion about what, if that property were to be for sale. Now, he clarifies in the email that I have in front of me that he doesn't know where these numbers are coming from and that he.
What numbers? The offer?
Yeah, correct, Your Honor. Because no discussion had ever occurred about what that listing price would be. No discussion occurred about a wire transfer.
Okay, all right, but counsel, something's going on. I have two realtors on opposite sides, regardless of what their authority is. All right. I have two realtors, and then at some point, according to the defendant in this case, there are communications with a lender. That
The
go ahead.
realtor who or the realtor who's standing on the plaintiff's side had I don't believe had any communications with the lender for Ms. Stevens.
Is that right or no?
I have email here with Kirk Glassel in communication, several phone call or a few phone calls, I should say several, with my realtor, and she was relaying information between him to the lender. And there's including the good faith deposit, the amount of that, including something about a back rent that and all of these other components that would,
Okay. Okay, that's my concern. It may very well be, Mr. McCurdy, that your client gave no authority for this person to act in this fashion. But what's clear based upon the representations of the court is that they were. And I don't know.
Ms. Stevenson has been putting forth since the conditional dismissal that she was wanting to purchase this home.
Mm-hmm.
After the affidavit went in with the order, I received this email saying, I've been approved for a mortgage. I'm going to try and put together an offer for this home. If any of those things are true, I don't know, Your Honor. Beyond that, no communications until the writ was posted to the door. And then all of a sudden this started as of last Thursday or Friday. If Ms. Stevenson would like additional time, we're happy to accommodate her. We can make any arrangements she finds like reasonable. But I don't believe the writ should be overturned.
Yeah. Evidentiary hearing. I don't know when I can do it. When did we set the current?
August 11th.
Okay. Afternoon.
Yeah. So
Okay.
Yeah, it was already at 1 p.m.
Got it. I understand. Um, the problem that I see here is that there's something else that's going on, which, as the defendant has stated, led her to do or not do things. Plaintiff may have a different version that she's coming up at the last minute, doing whatever. Regardless of all of that, I have two realtors. I all of a sudden have a lender involved. I would just say that if Miss Stevenson has gone to those extremes just to delay, it's a lot. I don't think that that's what she did. I don't think the communications that I've seen and the ones that are being described are that. Something, rightly or wrongly, it seems to me, was represented to her regarding the sale of this property. Okay.
Property was never listed. That's
right, but I don't.
okay.
I hear you, but if you had your, from the plaintiff side, your everyday run-of-the-mill property manager, not a realtor, they're just managing your property, make sure that repairs are done, collect whatever, okay? And she's having discussions with that person, then I might tend to agree that there's not enough there doing anything. This is different because this person's a realtor. And by the way, I don't think somebody goes up when somebody's a realtor and say, do you have the listing? I mean, I don't know that that comes out of anybody's mouth right out of the gate, unless it's the realtor that says that to somebody. You assume that they have the ability to sort of move in the way that they're moving, right? So I get it, but something transpired here that either Miss Stevenson was misled potentially, or something occurred where she just didn't understand it and how the transaction was going to go, or something. I think for your client, Mr. McCurdy, I don't know if she knows what the heck has transpired, because somebody is apparently, well, I'm not making this conclusion, but at least from Ms. Stevenson's perspective, somebody is acting on her behalf or their behalf. And it's just, it seems to me, doing things and making things that may be representations that have to stick to your client. But I don't know. Now, having said that, other problem, Ms. Stevenson, that you have is typically any agreement regarding the sale of property would need to be in writing, right? But so there may not have been an agreement, and that may be this court's ultimate conclusion. But I also realize that there are discussions that happen before there's any writing that's put into place. I mean, just in a practical sense. So from what I've seen today, I think it would be improper and imprudent on this court's part to issue to allow the writ to be executed. So at this juncture, the court is going to stay the order of eviction of the writ in this case. I'm going to order an evidentiary hearing on the issue regarding a sale. I will set that for August 11th, and I apologize for pushing it out to that point, but my docket is what my docket is, folks. And I'm going to try to take a vacation, or at least not be here. So August 11th, 2025, I will set that at 2 p.m. Okay, there's a criminal evidentiary hearing ahead of you, and I've got to take care of the criminal matter. But in the interim, I might suggest that the parties try to talk to get straight exactly what's transpiring on the plaintiff's side and what may have been said. Ms. Stevenson, you also, and one of the things that you said this morning is that you hadn't had time to make alternative arrangements regarding yourself. So I might suggest that you at least have a plan B, because I don't know what I'm going to rule on this. All right?
I agree.
All right. Thank you, folks.
Thank you, Your Honor.
Thank you.
Why?
They're on that side.
No, I'm going to give it to Lee. Why are you up here?
You don't put that on the front, yes.
This is that one.
Yeah. However, she filed more stuff. Defendant.
Okay.
Yeah.
Thank you. Court does call the case of BMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
Good morning, Your Honor.
Good morning, sir.
Morning, John.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Associate Banks occupant,
Pardon?
Doshia Banks, occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan, the property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
All right. Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
All right. Thank you. Ma'am,
Yes, Your Honor.
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and then you can go challenge it. With who?
With Whitlow. Ms. Whitlow.
Then you need to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to.
I don't know what you need to do, but.
Well, let me respond.
To what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim I was just led under
An
false.
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing. Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know that.
Okay. I know you don't know that. 'Cause it's not before you.
Correct.
I see. I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights on the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment in order, the appeal bond, I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high. at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you, Your Honor.
Thank you. Take that.
I know,
and
you didn't write anything.
We'll await. I did.
Oh,
No.
no, I don't think so. I don't know if Mr. Fink is ready on.
Mr. Fink, are you ready? But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute. Well, it's not hurting. I mean, I could go on, but I need about 10 minutes after that.
Thank you, Your Honor.
Court's in recess.
All right.
Are you gonna, may I, Your Honor?
Pardon?
I have an interest in the Anderson v. Lyon.
Yes, it would be O'Day, McFarland, Terman, and Jordan.
Okay. Because I had 4. She took my files down there. Okay. Then what I'm going to do is I'm going to stand in recess. I'm going to talk to the plaintiff first. Then I'll come back. I will get to you guys.
Okay.
All right.
All right.
Thank you.
Okay, so is EMS coming or are they already here? Yeah, okay. Okay, Mr. Nichols, Mr. Franklin, on Juan Sanchez. Good morning. Morning. Good morning. Good morning. All right, this is cause number 1830854, and sir, you're Juan Sanchez? Yes. And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One, I don't believe the subpoena ducis tecum was the proper way to try to get the information. Ducis tecum is an order to get somebody to bring something to a set hearing. So, but we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So under the rules that have to do with subpoena ducis tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests. And then I would approve you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that, Mr. Nichols let me know that, then we could worry about maybe a motion to compel and whether or not I think those things are or are not. But lab results of testing, money owed, all of those types of things, I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the.
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion are based on arrest out of county. And so his attendance record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations for the motion.
May I respond, Your Honor?
Well, let him finish, yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing. I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations, and they, of course, will be provided beforehand. And again, I don't think he's not entitled to have all that stuff. So
Sure.
I kind of agree with
So-
I don't know the subpoena directly to those agencies was the proper way to do this. And Mr. Franklin did make just a standard discovery request at the onset of his involvement, which was early May.
Right.
I don't have anything really responsive to that at this point.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible. Let me look at the motion itself. Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations and there isn't an allegation, then why would you, what is your argument that that would be relevant or discoverable?
Your Honor, my client is wanting to stay on probation, and the court may take into consideration his performance while on probation, including his payments, his report, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
Okay,
And
I don't
so-
disagree. I don't disagree. So, again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all have had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably. The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence. And
Yes, Your
so
Honor.
that's not the way we're going to do
The
it.
ducis tecum was set for the day that it was initially set for a hearing, and it did specify that date for the hearing, I believe. And we ended up moving the hearing date because of conflict.
And Judge, I'd ask Ms. LeBeau to go ahead and get everything together today.
Yeah.
To turn over.
I mean, yeah.
Unless there was something that the court was ordering her not to turn over.
I don't think on this list that there are, I mean, is there anything that y'all specifically had an issue with?
Ms. LeBeau, is there, or do you have any concerns you want to
If there's,
make the court aware of?
Your Honor, just with the clarification of, our departmental chronologicals, which include, anything that pertains to the case that happens, with chrono telephone calls, auto-generated, appointments, reminders, office visits, drug tests, anything that we enter into the system. But those are the chronologicals through the probation office, as well as releasing of the jail logs, his sex offender verification, interlock reports, because those were not listed on the subpoena, as well as the offense report through DPS, which was released to me and my under a supervision officer. So just to clarify, as to those items specifically being released that were not listed, with the exception of the offense report.
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion originally. I would also note that the chronologicals.
well, and these aren't, the reason you didn't get any of those is because those aren't his, they're theirs. And so they're not, I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out, though, I think whatever Mr. Nichols, y'all get together, obviously offense report. If y'all have the offense report and you don't even have it, then you need to get, I mean,
Right, I mean,
that's great.
it's
Everybody
all
can get
stuff-
the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be,
Unless, I mean, I guess
Not-
notes may be work product, but I'm not real,
that's what I'm thinking about, but it's
I'm
not
not
really
concerned.
attorney's notes, and so I don't know that that would
I
be an
would object to
issue.
that, Your Honor, on the grounds that it's not attorney work product. It is merely work product of an employee, and it is discoverable and relevant to the case.
And that's what I just said. You seem very frustrated, and I'm not sure why. I mean, I don't know,
I'm confused why there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access those files. It should just be produced by probation without a fight. And we got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
And that is alarming to me, that we would have to even compel anything under 3914.
this is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
And the
Your Honor.
last thing you want to do is talk over me.
Yes, Your Honor.
So I'm standing here, or sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative defensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to the individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay? So y'all get that done, and then we'll reset the case for just an announcement in what, a couple weeks or so? Fine with that?
Yeah, that should be fine, Judge. We'll be able to get everything scanned in and provided through the portal.
Perfect, thank you. All right, y'all are all excused.
Be needed?
I'm sorry? No, ma'am, if you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're going to have a hearing, we can come in on that date, enter pleas of not true or true to certain allegations, then we would reset it for a court date. And at that point, if you need to be here, let her know. If you need a subpoena, then you can get a subpoena. If you just need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay?
Yes,
Good?
Your
All
Honor.
right, thank you, y'all.
Thank you.
Is she back there with, is Brittany back there? Which one? That's on Mr. Miller.
Thank you.
Good morning. Thank you for coming real quick. We'll at least take care of Mr. Miller so they can get him. Okay. Mr. Coleman, we're going to take care of Mr. Miller. It's a competency.
Okay.
All right, this is cause number 241916. And are you Edward Miller? Good morning. And so Mr. Miller was evaluated by Dr. Hamza for competency to stand trial. I received that report dated June 26th of 2025. The finding in that report is that Mr. Miller is not competent to stand trial. Is there any other evidence with regard to competency? Ms. Holmes?
No, Judge.
And then at this time, I am going to find that Mr. Miller is not competent to stand trial, that inpatient treatment is required for competency restoration, order you to the appropriate facility. This is just to get you some help, Mr. Miller, okay? And we're going to get you some help, and then we're going to get you back in here. And it'll be for a period of not to exceed 120 days from the date that he gets to the appropriate facility. All right, you can go back with the bailiff.
Remind you, we added that on the guy from yesterday with the flight, Charlie.
Oh,
It's not on the docket anywhere, that's why.
and what was it set for?
It's just,
An announcement?
yeah.
What?
Yeah.
Oh, okay. But is it on the, is it going to show up here?
You may have to refresh your calendar, but it's yes.
Okay, all right.
Judge, if I did some.
If, it goes,
Does it still need to be okay, spending for him to remain?
yes. So the only other option would be to go through the civil, go go through a civil commitment would be an option. And so if you get that done, the case can get dismissed and then he can go a different route, but you have to get with your people on how to do that. I know Ms. Morfino's done it on some, but it,
I don't want to mess with his ability to get paid.
if it's, obviously there's some issues that need to be taken care of. So perhaps we get the initial competency restoration done and then do it at that
I'll
time.
make a note on file.
Yeah. Yeah, how did that feel coming
Reach down deep.
Oh my gosh, I don't say much, but I'm shaking still. Like, I haven't been that frustrated in a long time. Mr. Kimler, you have Reagan Howard. I just don't do well with that stance.
Mr. Smith and I are getting along now.
Thank y'all very much. Appreciate that.
There's not a bit of old friends.
That's an interesting way to start the morning.
On this one, I just been going through the motion. If it's something to or not to, then I'll ask for a bond. And she did have a email letters.
Good morning, ma'am. You're Reagan Howard.
Yes, ma'am.
Ms. Howard, would you please raise your right hand? Best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. Let me get this. And she's just going to plead to the motion.
Yes, ma'am. Yes, Your Honor, and I get it updated to the side, and Mr. Smith, there may be evidence he wants to put on right here.
Okay. All right, let me get this put up. Ms. Howard, in cause number 22-39924, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2024 for the third-degree felony offense of deadly conduct discharging a firearm, and that was a 6-year deferred probation. Is that correct?
Yes, ma'am.
And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department October 7th and November 1st of 2024. And is that true or not true?
Can you repeat that? I'm sorry.
The dates were October 7th and November 1st of last year, 2024, that you did not report. Is that true?
Yes, true.
Okay. Count 2 alleges that you're behind in your court-assessed fees. And is that true or not true? Count 3 alleges that you also failed to report June 27th, August 21st, and September 24th of 2024 to the probation department. Is that true or not true?
That's true.
Count 4 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. And is that true or not true?
That's true.
Count 5 alleges that you failed to immediately report your contact information as ordered to the probation department. Is that true or not true?
That's true.
Count 6 alleges you provided a urine sample August 27th of 2024 that tested positive for alcohol. Is that true or not true? Count 7.
Tied to the same UAPH.
So count 7 alleges that on that same date of August 27th of 2024, you also tested positive for cocaine. Is that true or not true?
That's true.
And then count 8 alleges on that same date, you also tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 9 alleges that you did not provide verification of performing the community services required. Is that true or not true?
True.
Count 10 alleges that you did not provide verification of entering and successfully completing the anger management program. Is that true or not true?
Not
Not true. I didn't get assigned to anger management.
Okay. Count 11 says that you did not submit to alcohol or drug screening September 9th and September 16th as And then apparently you had possessed a device or an object for the purposes of providing a fake specimen. Is that true or not true?
Not true.
Count 12 alleges, again, that you're behind in your court-assessed fees. This was done a little bit later, so the amount is more. Is that true or not true?
True.
And then count 13 alleges that you didn't provide verification of entering and successfully completing the moral recognition therapy, the MRT program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 9 and then 12 and 13 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to those counts freely and voluntarily, find them true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing. And we'll get an updated pre-sentence report done. And if at that time the state wishes to put any evidence on with regard to counts 10 and 11, they can do so. And then anything that you think is important for me to know at that time, get that information to Mr. Kemmler. He'll present it to me on your behalf when we come back. And this is unagreed.
Correct,
Jody.
Your Honor, there's nothing.
Okay, all right.
Your Honor, we had asked for a bond. I think if the court would set a reasonable bond for Ms. Howard, and she were able to post that bond, she would be able to demonstrate to the court.
That's denied. I'm going to find at this time it is in the best interest of our community and under the Article 1517 that even though this is a deferred probation, based on the nature of the underlying offense, which is a deadly conduct discharging a firearm, the fact that it looks like Ms. Howard has done pretty much nothing, including not reporting while she's on probation, and when she did test positive, that it is not safe at this point until I have more information for her to be out. So that's denied.
You did have her support letter.
Yes, and I've already received those, and we'll get those to probation as well so that they can be part of that pre-sentence report. Okay, you can go back with the, what's that?
So is ISF off the table?
Well, I don't know right now until we come back for sentencing. So probation will come talk to you, talk to Mr. Kemmler. I'll get all the information about what's been going on, and then I'll make a decision when you come back about whether I keep you on probation, revoke your probation, keep you on probation, send you somewhere for treatment. It just depends on the information I get when we come back, okay?
And I'll be out this.
Okay, you can go back with the bailiff. Mr. Matuska, you've got Von Zell Hall. Good morning.
Morning, Judge.
Good morning, you're Von Zell Hall. And in 24-1747, Mr. Hall is charged with murder, and what is the announcement?
Your Honor, at the last setting, I requested some digital media. Since then, Mr. Nichols has done an impressive job of providing most everything I need. Unfortunately, I think some of it hasn't been provided to him. And I've discussed this with him. I'm trying to get a few more items I think are pretty important to this situation before we announce. If I could have a 30-day reset. I think
There was
I can take
some
care of it.
follow-up testing and some documentation that he was asking that I don't see in my file, so we need to find out if it exists, where it is, and things
Okay.
like that, so.
All right, so I'll do one more reset. Y'all can work on that. If there's anything that you can get, obviously get that to Mr. Matuska and Mr. Hall. Mr. Matuska will be out there, I'm sure, to visit with you once he gets everything to see what y'all want to do at the next court date, okay? All right, you can go back with the bailiff. Thank you.
Your Honor, I've discussed all that with him already.
I figure. Thank you. We're, impressive. You've done an impressive.
Well, that was.
Can you tell, you,
That was a lot, but that's okay. We appreciate that this morning. We're resetting both of Mr. Radford's cases this morning. So, Lenny Leday and Traylon Martin. Okay.
Judge, that Cody Dent, I told you, Auburn was hired on 2 of the cases, and Marvin was on the other. Marvin just said that Auburn's gonna take care of all of them.
Okay.
So I put him in the system, so.
Okay.
Yeah, I'll just refresh your calendar.
Okay.
It's correct.
And we reset Joel's, correct?
Yes, ma'am.
That's good. I just feel like I need a break. Mr. Rojas on Anthony Williams. Good morning. You're Anthony Williams. And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
What's your signature? Mr. Williams, in cause number 240401, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from December 7th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year term in prison, but that would be probated. You'd be on probation for 7 years. There's a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Sir, state tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can get a pre-sentence report done. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today so they can start that report, and she's sitting at that desk right over there. All right, we'll see you back at sentencing.
Yes, ma'am. Thank you.
Yes, sir. Mr. Rojas, you have Theron Jackson. Good morning, you're Theron Jackson.
Yes, ma'am.
And Mr. Jackson was previously in court, entered pleas of true to counts 1 through 5 in each of his motion to revoke unadjudicated probations on probation for aggravated robbery. Actually, 3 cases. an aggravated robbery, and then 2 aggravated assaults with deadly weapons. And cause numbers 241324, 1323, and 0883. I've received the updated pre-sentence report. This was unagreed, and has everyone had an opportunity to receive that report and review it?
We have, Your Honor.
Are there any additions or corrections to that report? All
Not from us, sir.
right, Mr. Rojas, you may proceed.
Judge, Mr. Jackson recognizes he's on probation for some serious offenses. And that, you know, in my opinion, looks like he needs help. And main problems come from mental health issues. He's homelessness, he's got lack of transportation, and he's got limited family here in the area. He tells me that when he was first released from jail, he didn't have a place to live, didn't have any transportation. That's the reason for not being able to get to probation department in the beginning. He's been on probation for such a short period of time. He's been unable to get the benefit of the resources that probation has to offer. I understand all that's because of his not attending probation. But again, I think that all stems from the homelessness and the lack of transportation and the mental health issues. He is trying to get help for himself. He does have the application to get his government benefits. He's got a contact with someone from MHMR if he were allowed to stay on probation. He tells me that he has a place to live now. He's going to be living with his cousin who does live here in Beaumont. He is hopeful that he can get his job back at the place he was working for at the barbecue restaurant.
Yeah, that's good.
Hold on.
And of course, that all is going to depend on him actually going to probation. And he tells me now that he does understand that the importance of getting there, he will do everything he can to make sure that he does get to probation if the court were to allow him to stay on probation. And that's what he's asking the court to do this morning, Judge. And at the proper time, I think he does have a statement to make.
Go ahead.
Hello, my name is Darren Jackson. I'm writing this letter pleading for mercy. I started my probation off on the wrong note. Everything I had on probation was in first place. I ended up losing my cell phone and the place that I was living. The people found out that I was on probation and they kicked me out the house. And I didn't have, they kicked me out. I got kicked out of the place I was staying at. And the same night, the police had came and arrested me for some improper, like some things that I didn't do. And they said I was under intoxication, but I wasn't, you know what I'm saying? Because they was all fighting and stuff like that. And they put me in jail for one night for intoxication, but they didn't have no breathalyzer or nothing saying that I was intoxicated, and they said I was intoxicated, and they was lying. They was lying on me. They didn't have any record or proof of intoxication. I got to jail and they released me the next day for public intoxication. I reported the next day, the day I was supposed to report. You know how they let you out of jail. You know what I'm saying? At like 3 o'clock. It was raining so bad. It was flooding. I didn't have nowhere to get there. So I walked. The next day I waited till it stopped raining, and it was unflooded. And I walked to the probation office, and I told the lady that I didn't have my social security card and my ID, and she said she was going to help me do it. And I was very excited, Judge, for trying to get my GED. I was very excited about going to school, and man, the lady kicked me out of the house where I was staying at, and I had to move in the hotel room. And I ran out of money, and bro, it just all went downhill from there. Yeah. And if you can find any way for me to get back on probation, I promise I'm going to do the right thing And, you know, I'm a good citizen and I help anybody I can. I'm a minister of music. I go to church, Solid Rock, Church of God in Christ. And yeah, man, I've been trying to stay out of trouble. I've just been running up on hard times, yeah. I just need a second chance.
Ms. Monfino?
Judge, I'm not unsympathetic to his situation. I don't think it's something that he's just coming in today saying that he's had these problems. I think they've been ongoing. I think that's why we initially wanted to give him the opportunity of probation so that he could participate in the mental health caseload. Obviously, he's very lucky to have Ms. Core as his officer, but I have spoken with her several times about this, and she has gone above and beyond just trying to make contact with him to bring him in to say, these are the resources we try to have to help you, and they just can't ever find him. I'm not suggesting that necessarily my position is revocation, but my position would be, Judge, if the court gives him this opportunity, he does not take advantage of it, and he does not do what Ms. Core needs him to do, that the court orders him to do, that my recommendation would be significantly higher than it would be today on revocation based on the underlying law.
You probably haven't even had enough time to know, I guess, my question, Ms. Core, would be, if I continue him on probation, would something like cognitive track of ISF be
Yes, ma'am.
helpful, or that, or either special needs safety? Which one do you think would be more appropriate to help him get a good start before he gets back out?
I would think very highly of his special needs safety for him.
Okay. Okay. I mean, Mr. Jackson, everybody wants you to be successful,
Yes, ma'am.
but you're the only one that can make that happen.
Yes, ma'am.
You have all the resources. Ms. Core wants to help you. Probation has all kinds of things to help you, but you have to, they're not going to come, she's not going to come find you.
Yes, ma'am.
So, if I give you this opportunity today, you're going to go get some help in custody. Listen, and when you're out though, and when you're finished with that treatment,
Yes, ma'am.
it's going to be your responsibility to go where you're supposed to go, to let her know where you're living, and she's not going to go try to find you. You don't show up, then you're going to be back in here and we will not be having these conversations. Today, I could send you to prison for the rest of your life for violating your probation. Right now, today, for life, for 50 years, for 30 years, for 20 years. An aggravated robbery and 2 aggravated assaults with deadly weapons. You should probably be going to prison. So you need to understand that this is it. There's no second chance. This is your chance. All right. So I'm going to find that you entered your pleas of true to counts 1 through 5 in all 3 cases freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probations and find you guilty, but I'm not going to do that. I'm going to continue your probations in each of your cases. I'm going to order in each of your cases that you enter and successfully complete the special needs track of SafeP. That's going to give you all kinds of help to make sure when you get out, you're ready to go and you'll be making better decisions. You won't have any issues, hopefully, with regard to any type of drug or alcohol abuse, and you will also have aftercare, a place to live, and things like that. So you're going to have what you need, and it's going to be up to you. All right. Good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Core. Ashley Faye, Mr. Rojas. Good morning.
Judge, we think we can do this. She has 3 prior state jail penalties on the same day. They're not sequenced, but I think we can still do a third degree.
Yeah, they don't have to be sequenced. Only regular ones to make it a second degree have to be sequenced.
We're worried.
That's our old drug court days. Toby, you should remember that.
But I looked at them and went, they're all the same day. I went,
Yeah, I remember that from those days. Okay, so she's gonna go. Let me say this the right way.
The audit sheet's been emailed, Judge.
Thank you. Good morning. Are you Ashley Faye? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Faye, in cause number 250355, you are charged with the state jail felony offense of credit or debit card abuse from October 16th of 2024. Your indictment alleges that you were previously convicted of theft, a state jail felony, March 15th of 2019, in 3 different state jail felony cases of theft on that same date. And how do you plead to the charge? And are those prior theft convictions true? Answer out loud, please. Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you not understand something?
No, I kind of wanted to ask for probation.
So this isn't where you do that. Y'all have negotiated with Mr. Rojas. Mr. Rojas negotiates with Mr. Hoffpower. They do all of that. I don't get involved in that process. So there's a couple of things you can do. You can, go ahead, Mr. Rojas.
So we did have an offer for a cab judge. We talked about that, and this is the one that she chose. If you have any second thoughts, we can talk about that some more.
Do you want to go talk to Mr. Rojas about that cap? The cap would be pleading open to me, where I could give you time in prison, I could give you probation. It would depend on all the information that I was given at a later hearing for a sentencing hearing. If you want to do that, then
Yes.
you do want to do that. I think you're going to have to do the unagreed, the different.
Yeah, but different paperwork.
No, you're not. With everybody's permission, I can make those changes on this.
Okay.
Yes, ma'am.
What is it, cap of what?
Cap of 5.
How do I?
Should just touch it.
No, it's not. It's writing with it. See, I'm just scribbling on it.
I'm cracking.
So on the agreed punishment recommendation page, I am marking off the cap of 5. And then I think that's really the only thing that needs to be changed. Okay, so then let's go back. The agreement that you've reached is for a cap of 5 years. And I want to make sure you understand, it sounds like you've gone over it with Mr. Rojas, that what that means is that you're leaving your punishment up to me. As long as I give you 5 years or less, I can consider probation, you cannot appeal. Do you understand? And you have an absolute right to have a jury come in and determine if you're guilty or not. You can leave your punishment up to a jury. If we go forward this way, you're waiving that right. And is that what you want to do? Right. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Fay is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty and true freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a report that'll give me more information about you, your history, your cases, and then we'll come back for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas and he will present it to me on your behalf when we come back. All right, go back with the bailiff. Yes, ma'am. Do you have anything else?
The add-on.
Oh, okay.
Can you see it there?
Give, that's for a bond.
And she was ran on a new case. She's on strict probation, and Judge DeRuin sent you an email asking.
Of course it did. Sure, I remember that.
There's not a motion filed or anything. I think you just set this on your own. I think she got a baby at home.
Oh. Yeah, and okay, but nothing was filed. She just made the request of, let's get Janicia Leonard out, and I'll just put it on the record, since they. I just decided to, well, and what went on, I don't know if you know, so last week I received a message from Judge, yeah, DeRuin.
The jail has a policy in place for that, maybe the pump.
I'm not concerned about it necessarily. I just wanted to put something on the record because she made it, I guess, enough impression on Judge DeRuin. And so even without a motion, I just wanted to at least put some stuff on the record. And then obviously if at a certain, I'm not going to set a bond today, but I'm going to explain where we are, why there's not a bond. And then if you want to file something and we have time for a hearing with some specific information, once you kind of get, then I'll reconsider it. But let's just. Yeah, well, there's that. The only thing, the issue, one of the issues I have is the new case. It's from 23. And so actually I might consider a bond just because if she hasn't been arrested since 23. Let me look at.
I would want 3 days to prepare, but if
we can reset it for next week. I just want.
If you want to do it today, I'm not opposed to do it today. My argument would be, Judge, it follows the same average.
Yeah, I just the length of time. I want to know if she's been doing well on probation. Other than that, that's one thing I would like to know. And so, I think let's reset it for next.
We can reset it.
Let's do that. Let's reset it. Tell Sharon, never mind. Let's reset Miss Leonard for next week. And then I would like to have, I think Miss Core already left. Miss Core was her, that's okay. For next week, if she can be here, just so that I can, because of the length of time of that new offense allegation and when it was indicted, I think I'll consider that, and that'll give you time also, Mr. Coleman, to see what's going on and what we can do. All right, thank you. Okay. Mr. Samuel, you have Cody Dent.
Yes, Your Honor.
Good morning.
I'll discuss that, so I'll be filing that afterwards.
Okay. If you're requesting, make sure since you're hired, you'll have to do an affidavit of indigency if you're asking the county to pay for anything.
I will.
So make sure you attach that with it when you do it. Good morning. Are you Cody Dent?
Yes, ma'am.
And Mr. Dent is on probation in two cases, 13-17772 and 22-41052 for the offenses of obstruction or retaliation and theft of property. Those both have motion to revoke pending. And then there is a new allegation or new indictment in cause number 250807 of burglary of a building. And Mr. Samuel,
Yes. Your Honor, I've been hired to represent Mr. Dent. I went out and visited with him this past weekend, and I've also spoken with him this morning. And as a result of my evaluation and talking with him, I believe it's merited to have someone appointed to give a professional evaluation. We realize that he is on probation. I realize there is a new charge. This is our first setting. I've not had an opportunity to complete discovery, but I think upon getting the information from discovery, and if we can set for bond hearing at a later date, maybe next week, if possible, we believe that the results of that evaluation will show that there's possibly some alternatives that are available.
So it's set for bond hearing today on those motions, but you want some time to get up to speed on that other case. You want me to put that off, just hold it?
Yes.
Okay.
Yes.
All right.
At least until next week. I'd like a quick turnaround because right now there is no bond.
Right.
And he needs to get assistance.
Okay. An evaluation won't happen in a week.
I understand.
Okay, so but you still think give you a week to get up to speed?
Correct.
Bond hearing next week?
Correct.
And then I'll look at your motion for the evaluation. We'll take care of that.
And
Right.
I've talked with the prosecutor.
Okay. We'll reset it. How's next week? Are we?
Yes.
We're good? Okay, we'll reset it for 1 week for a bond hearing on those two motions.
Right.
Thank you.
Thank you, Your Honor.
When you're finished, I'm saying. You said he does need to fill out. Here's an affidavit.
Mr. Lewis, on Justin Franklin,
I just wanted to-
So, okay.
good morning. Are you Justin Franklin?
Yes, ma'am.
And in cause number 250514, Mr. Franklin's charged with aggravated robbery. Mr. Lewis, what is the announcement?
Well, Judge, I'm Mr. Franklin. I understand that the plaintiff witness had been in touch with the state on this one.
Judge, may I put a few things on the record, please?
Yes, ma'am, of course.
First, may I have the name Kayla Davis called?
Would you call the name Kayla Davis, please? Good morning, ma'am. Are you Kayla Davis? Ms. Malfino, do you need some time maybe to visit with her, or do you want to go ahead and put something on the record?
Judge, if you
Okay.
just not swear your.
Ms. Davis, would you please raise your right hand? Do you swear or affirm the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, ma'am. Thank you. Go ahead.
Ms. Davis, would you please state your full name for the record?
He's Taylor Davis.
And Ms. Davis, what is your relationship to the defendant, Justin Franklin?
He's my husband.
Okay, and how long have you all been married?
We got married in January.
In January? And you know what we're here about today, right?
Yes.
The aggravated robbery that he's alleged to have committed against you and your children, right?
Yes.
Where he held you all at gunpoint and stole your purse and wallet, right?
He didn't hold us in gunpoint and he didn't steal my purse nor wallet.
Did you tell the police that that's what happened?
No, ma'am.
Okay, so if that's what the offense material reflects, and that's what the grand jury proceeded on with an indictment for aggravated robbery, are you saying under oath to the court today that that did not happen?
Yes.
And you have many times called my office, asking that the case be dropped, correct?
Right.
You've come in and signed a non-prosecution affidavit.
Yes, I have.
You have called saying that this did not happen and that you're not going to cooperate with the state, correct?
Yes, I have.
Are you in fear of Mr. Franklin?
No, I'm not.
Is he pressuring you to do this?
No.
And do you understand that if the state does not proceed with this case, that you're taking matters into your own hands?
Yes, I do.
With respect to your safety?
Yes, I do.
And that's what you want me to do.
Yes, drop the case, please.
And you're asking Judge
I'm
West
asking
to
Judge
allow me
West
to
to-
drop the case.
To drop the case.
All right. All right, you can step back.
Thank you. And Judge, just for the record, if I may, obviously with those facts, obviously the court is aware of experiences you and I have both had in the past. I think there was something more to the incident. She's obviously not going to cooperate with me. She's obviously also his spouse. And so at this time, with the court's permission, I would move to dismiss, but I just wanted to be sure all of that was on the record so that if something were to happen in the future, everybody is aware that those were specifically her wishes.
All right, if that comes through based on all of that, I don't know how you can do anything else, and so I'll sign that. Mr. Franklin, I'm not sure what, if anything, happened. My thought is something did happen. Hang on, just let me talk, okay? Don't talk yourself out of this, because here's what can happen. It's not easy, but it is possible to go forward with cases without the complaining witness. So whatever happened needs to not happen again. You need to get a grip on whatever anger, whatever issues you have. If you've got someone here that cares about you and you want to be a part of their life, that's not what you do to people that you love. And it's definitely not what you do where there are children involved. Do you understand? All right, go back with the bailiff. Yes, ma'am. Mr. Parker, you have Tracy Haynes. Good morning. Are you Tracy Haynes? And this is cause number 240514. I'm going to take judicial notice of the court's file. Mr. Haynes was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I received a packet from them dated June 23rd of 2025 with that report from Dr. Samantha Guzman with the opinion that Mr. Haynes has achieved competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No.
Then at this time, I will find Mr. Haynes is competent to stand trial. And will he waive the formal reading of the indictment, Mr. Parker?
No, Your Honor.
And are we going on count one only? Hold on, let me get it correct then. All right, Mr. Haynes, in cause number 240514, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of obstruction or retaliation from February 3rd of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
The stuff on the computer.
The stuff on that computer tablet, did you go over that before you signed it with Mr. Parker?
Yes.
And do you understand those documents that you signed? Speak up, please.
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow your agreement, you can't change your mind later. Do you understand?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone. Speak up, please. When you're answering, I need you to speak up. State tenders number 1.
No objection.
It's admitted. All right, so I'm going to find that you entered your plea of guilty to count 1 freely and voluntarily. Find that you're mentally competent again and that you understand the nature and the consequences of this plea. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation and sentence you in accordance with your agreement to 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, so you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Mr. Parker, you've got Jack Hooper. Good morning, sir. Are you Jack Hooper?
Yes, Your Honor.
And in cause number 17-27896, Mr. Hooper is on probation for driving while intoxicated, third or more. There was a motion to revoke filed. We were previously here. Entered pleas of true to counts 1 through 6. I've received an updated pre-sentence report, and the agreement was for a cap of 4 years. Is that correct?
That's correct, Judge. He's indicated to the probation officer, indicated to me that he would rather not be put back on probation. He's asking to be sentenced to 3 years. He doesn't have, he doesn't have any new cases as violations or the possession, testing positive. He seemed to report to the probation department and did everything he did. The problem was he had an issue with marijuana. We're asking that, I think he should be given some consideration for that. We're asking for a 3-year sentence.
So you stopped reporting back May 5th of 2021. So didn't really report as
I apologize.
directed.
I spoke that.
You've been an absconder since 2021. Ms. Malfino?
Judge, I think the consideration that he was given was with the cap of 4 years. I completely understand if based on the original PSI and his history and his attitude, the court does not think that that is an appropriate amount, but I would obviously recommend revocation, whatever amount you think is appropriate if we need to revisit that issue.
What happened with the Sabine County DWI back in 2017 at the same time as this one?
They dropped it.
Okay, at this time, I'm going to find that you entered your pleas of true to counts 1 through 6. Find those counts true. Ms. Malfino is exactly right. You're lucky that you made a plea agreement for 4 years, because I'm not really sure that not showing up since 2021 and just saying I want to take my time and be done with it is the kind of attitude that I appreciate. But I'm going to find sufficient evidence at this time to revoke your probation, and at this time revoke your probation, reassess your punishment to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you the trial court certification that shows this was an agreement that I followed, and so you have waived any right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Jeremiah Johnson. Sentencing.
Where did you see that?
What?
Where did you see the well? Am I asking?
It was on the second page at the top, I think. Let me see that PSI that I was just looking at real quick.
Okay, maybe.
You see what I'm saying? At the top.
It wasn't one of the allegations. That's why I was looking at the wrong thing.
Because the motion was filed way back then, I guess. So that's why it hadn't been. Good morning. Are you Jeremiah Johnson?
Yes, ma'am.
And Mr. Johnson was previously here in cause number 250330, entered a plea of guilty to aggravated robbery, and 250331 also pled guilty to aggravated robbery. Cause number 250408 and 0409 pled guilty to theft of a firearm. The agreement on these were for a 10-year deferred on those two aggravated robberies and a 2-year term probated for 5 years on the theft of firearm cases. I've received the pre-sentence report. Has everyone had an opportunity to review these reports? Or the report? Are there any additions or corrections? So I don't know about all this. Not real sure I want to go along with this plea agreement. Mr. Johnson?
Yes, ma'am. I promise that I'll do right this time.
This time?
Yes, ma'am.
You have been in trouble for breaking into people's cars, stealing guns, shooting at people over and over and over again.
Yes, ma'am. God can show me that this is not nothing I want to do in life.
When did he show you that?
Being in jail, incarcerated.
You've been in jail before. You didn't find God when you were there before?
Yes, ma'am. I'm not making no excuses.
Here's the thing. I hope you have.
Yes, ma'am.
I hope that you have found him. The problem is you lose them when you get out of jail.
Yes, ma'am.
And that's what a lot of people do, is when you're looking at time and you're incarcerated, and you're like, oh, I don't want to do this. And then you get out and you go start doing the same thing because you think you're cool and you're going to go steal guns and you're going to shoot at people when you're lucky you're not here for murder.
Yes, ma'am. I gotta be here for my little girl. I can't mess up no more. I can't afford to.
You're how old?
28.
You're 28.
Yes, ma'am.
You're way older than old enough to know better. You know, this is something I see a lot of times with these 15, 16, 17, 18-year-old kids. Your child's 7 years old.
Yes, ma'am.
So it's not like you have a baby and all of a sudden you know you need to be there for her.
Yes, ma'am. I know. I made a few mistakes in my life, but I'm willing to try to.
That's an understatement, don't you think?
Yes, ma'am. I understand.
I appreciate too that you're being honest with me today. But I have to look out for the community as much as, you know, I kind of have two things I've got to do here, figure out what's best for you, but also what's best for our community.
Yes, ma'am.
Your Honor, I will say when I first met with him that, I mean, early on, he's just said, I'm tired of this life. You know, I don't know why I'm doing this and I need to get my stuff together. And do you have people, I understand exactly what the court says. Everybody finds God and, I mean, Jesus in jail, you know, and
But sometimes I think there's some truth that when you're sitting there and it opens your eyes that, you know, you do realize that I'm getting too old for this. I'm just ready to settle down and do what's right. And he seemed to have that attitude when I first talked to him.
Listen, I mean, I just ask if you give me one chance, just one chance to prove myself.
So I want to make sure, and we're going to go over that. If you get this chance and you violate it,
Yes, ma'am.
you got the rest of your life that I can give you in prison.
Yes, ma'am.
And when I have to spend some time and it bothers me, a lot of times I don't remember. People say, oh yeah, you remember when you put me on probation? I don't. I'll probably remember you.
Yes, ma'am.
Especially because you put things on your face so people can remember you by them. Probably not the smartest thing either, right?
No, ma'am.
Okay. Any reason not to go forward with sentencing, Mr. Smith? All right, so here's what I'm going to do, Mr. Johnson, because of my concerns.
Yes, ma'am.
I'm going to give you an opportunity, but I'm going to hopefully give you some tools to be successful.
Yes, ma'am.
I'm going to find in each of your cases that you enter your pleas of guilty freely and voluntarily.
Yes, ma'am.
And find sufficient evidence to find you guilty. In cause number 250330, defer all proceedings, place you on probation for a period of 10 years.
Yes, ma'am.
You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'm going to go through certain conditions in a few minutes. In cause number 250331, find sufficient evidence to find you guilty. However, I'm going to follow the agreement, defer all proceedings, place you on probation for 10 years. You will pay a $500 fine in that case as well and follow all of the rules and conditions of probation. In cause number 250408, find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that, you'll be on probation for 5 years in that case. You're also ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Cause number 250409, also find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that for 5 years. And you're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. One of the conditions of your probation in each of your cases is going to be that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program, so you're not getting out today. But I'm doing this to continue you hopefully making the better decisions. This program is all about making better decisions. Staying away from the people that you need to stay away from. If you really want to change your life, you can. People do it. It's not easy sometimes, but you're going to be given the tools. And if you don't, then you're back here. Okay? And so here's something that's very important though. You have a handful of write-ups in our jail. I see those. I'm going to see if you have any more between now and when you go to ISF. It will be a violation of your probation if you have more incident reports in our jail or if you have any in ISF. So if you are disrespectful to those officers that are just out there doing their job, if you're fighting, if you don't button your jumper up because you're too cool to button your jumper up, just follow the rules. When you're out and you're not in custody, you can make whatever decisions you want. When you are in custody, you're going to follow those rules. If you don't, again, that's part of your probation now, is that you follow all of those rules and don't get in trouble. You could be back in here on a motion to revoke your probation before you ever hit the streets again. So whatever's going on in the jail, you better go in and say, whoever else is messing around, get on your bunk, do what you're supposed to, get to ISF, get out, do what you say you're going to do. Okay?
How long ISF?
It's a 90-day program. Okay? So you've got two separate things going here. Now you've got the deferred probation on those aggravated robberies, which means at this time you don't have a conviction on those cases. That's a great thing for you. It also leaves it open though. If you violate any condition of your probation, you're back in here. I can convict you of those offenses and you could be sentenced to anywhere in the range of punishment, which is between 5 years and up to the rest of your life in prison, the whole range of punishment. Also, if you violate on those theft of a firearm cases, you've already agreed in those to the maximum punishment, which is 2 years in the state jail prison. So if you violate, you've already agreed to those 2 years. Do you understand? Okay, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Not just any charges, more felony charges. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, you can, or how long that lasts, you can talk to Mr. Parker. All right? Good luck. Take advantage of this opportunity. What? Oh, okay. Garson Mendoza. Mr. Lewis. I'm sorry, I didn't realize you were here. Y'all let us know as soon as those are ready, and I'll try to get you out of here. And Ms. Burge, if you'll please raise your right hand, do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, sir.
Thank you. Good morning. Are you Garson Mendoza? No. And this is cause number 250304. Will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Mendoza, you're charged with the first-degree felony offense of aggravated robbery from December 1st of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis, with the interpreter? And do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, that you're waiving any right to appeal? And it looks like the agreement that you reached is for a 10-year deferred probation, a $1,000 fine, and you would be required to follow all of the rules of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And state tenders number 1?
No objection, Judge.
It's admitted. Is there any evidence that Mr. Mendoza is not competent?
No, Judge.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing so we can get a pre-sentence report done that'll give me more information about you and your case, and then we'll come back later for sentencing. What is the state's position with regard to a bond based on the nature of the
history is young age, he's 18 years old. Just was several classmates that
I can't hear you.
I think he was less than the other defendant, or a co-defendant in this case.
I'm not going to change the bond based on his age and the nature of the offense. A lot of times what I do in these is possibly ISF or something anyway, just because it had to do with a robbery and a weapon, and he's young. So let's just see what the pre-sentence report says. All right, so you can go back with the bailiff. Thank you, Ms. Bursch. Deontay Reed, it's a sentencing, Mr. Lewis.
Yes,
You can tell he does
To a full comprehension.
enough. Yeah. Yeah, I'm glad you came, because it was, especially with something like this, you don't want there to be any miscommunication.
Exactly.
Good morning. Are you Deontay Wayne? Or Deontay Wayne Reed, I'm sorry. And Mr. Reed was previously in court and cause number 240838, entered a plea of guilty to the state jail felony offense of theft of a firearm. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
State has, Judge, I suspect it's something on page 1 of the court.
I
have.
Mr. Lewis?
Yes, ma'am, Judge. I've spoken with my client about this, as far as his assessment accountability and for his admission to this offense. At that time, I could tell you, Judge, after speaking with him, he understands the issue with that, as far as his making a decision to try to get probation, as he's talked about here in the PSI. That this would involve him not just taking responsibility, but being honest and truthful about his plea, whether he was guilty or not guilty. And of course, at that time, explaining it to him that way, he's prepared, of course, to truthfully admit to his involvement in what he did in his offense, which he says he did commit this offense at that time.
So you either did it or you didn't do it. And so if you did it, then you're getting a great opportunity. If you didn't do it, then that's what juries are for, and that's why you would go to trial. So did you do it or did you not do it?
I did.
Okay, and do you want me to go forward with this? So what happens is you're gonna be spending some time with probation, and you've got to be honest with them the whole time you're on probation. They're there to help you. And so if you try not to take responsibility and try to diminish things that you're having issues with, then you're going to end up right back in here and looking at going to prison. So it's very important that you're open and honest with them. Do you understand?
Yes, ma'am.
Okay. All right, then, any reason not to go forward with sentencing? All right, Mr. Reed, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that. You'll be on probation for $1,000. You will also be ordered to pay
Is that probation for 5 years?
5 years.
What did I say?
For $1,000.
It's been a long morning. Y'all are all like, what is happening to her? Okay. You're going to be on probation for 5 years. You're going to be ordered to pay a $1,000 fine. I was reading faster than my mind was going. You're ordered to pay $1,500 in restitution also, and to follow all of the rules and conditions of probation. If you do that, this is a good opportunity for you because you're going to be able to serve that 2-year sentence while you're out on probation instead of in state jail prison. The other side of that, though, is if you violate any condition of probation, you'll be right back in here and you'll be looking at that 2-year sentence that you've already agreed to. Do you understand? There's going to be, I want you to get your GED is going to be ordered for you to get your GED. That's to help you so you can get better jobs and do better things. There will be mental health treatment if you need any kind of issue. Everything that they offer you and tell you you need to do is ordered. And so you're required to do that. And it's all meant to help you. Okay. So you're welcome. And so I'm handing you somewhere the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. Yeah, I think I'm out of my words. I think I ran out of words the very first thing I did this morning. That's the whole problem today, is that got me off my game. Desmond Jones, Mr. Lewis? Because I keep thinking about it and how I'm going to handle that. I'm not done. I don't think I'm done. I could tell as soon as I did something, everybody's face went. What's she talking about? Good morning, sir. Are you Desmond Jones? And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Jones, in cause number 250610, you're charged with the state jail felony offense of unauthorized use of a vehicle. That's from March 28th of 2025. And how do you plead to that charge? I'm sorry?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No objection.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle, sentence you in accordance with that agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. Ms. Holmes, you've got Tilia Mills.
Yes, ma'am.
Thank you, Mr. Lewis. Have a good day.
Thank you, Judge.
You okay over there? Good morning. Are you Talia Mills?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Mills, in cause number 240549, you're charged with the state jail felony offense of theft with previous convictions from November 4th of 2023. The indictment alleges you were previously convicted of theft July 14th of 2022 on 2 different cases on that date in Montgomery County, Texas. And then after those were final, you were convicted 2 times on June 21st of 2023 of theft in Harris County, Texas. And how do you plead to that charge?
Guilty.
And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Mills is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft with previous convictions. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you a trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am. You can go back with the bailiff.
Okay, this one.
Renecia Segura, Ms. Holmes?
Yes.
I feel like they've just lots of work. Oh, this is an NTRP. Good morning. Are you Renecia Segura?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Segura, in cause number 231869, I have a motion to revoke your community supervision. Shows that you were placed on probation July 29th of 2024 for the offense of theft of property with previous convictions. And that was a 2-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense of theft in aggregate amount January 29th, 2025 in Harris County, Texas. And is that true or not true?
True.
Count 2 alleges that you failed to avoid persons or places of disreputable or harmful character, and that you were at a location, you were arrested at a place where a crime had been committed with individuals who had previously been convicted of crimes. And is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And because they're actually true?
Yes, ma'am.
Give me a minute here.
Judge, I'd reviewed some of the Harris County offense material. She was essentially an accomplice while other people were committing theft in this instance.
I'm gonna real quick look back at the pre-sentence report to see that all that the criminal, how many we've got.
A lot, and I won't say it.
Oh, yeah, no. I'm not accepting this. My notes, I sent you to ISF already. And my note says it was a cap of 15 months at that time. And I wrote on here that you deserved the whole 15 months. And it's like Mr. Lewis was your attorney at that time. And he and Ms. Holmes are both doing quite the job for you. But 8 months with 7 felony convictions for theft, 5 more arrests, plus this one, and now you've been arrested again, is not something I'm going to accept. Absolutely nothing less than the 15 months that was the cap in the first place. So it's either something like that, or it's an MTRP. I don't have to, y'all go talk about it. I'm deleting the paperwork. All right, go back with the bailiff. If y'all come up with something today, then that's fine. If not, we'll, but I deleted it. You'll need to redo something.
I'll say I told you so when I go down the offer. Can I have a note on my file that I argued for the full 15?
Well, then I don't, then why? Then throw it back in my face.
Well, I didn't want to on this one.
Well, it deserved it though.
They gave her like 30 days time served.
But that's Harris County. They give 30 days time served on aggravated robberies.
They do like,
I mean,
they do 45.
that doesn't count. That's not,
They do 45.
absolutely. When there's something like that, no way. Okay, Jalen White.
So the offer, we're unagreed on the type of probation. So
Okay.
State's offering straight, we're asking for deferred.
So it is an agreement with regard to probation, just not the type. Okay, thank you. All right, so are you Jalen White? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Let me get to it. Mr. White, in cause number 24-0038, you're charged with a third-degree felony offense of possession of a prohibited weapon from July 7th of 2023. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am. I did.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it's my understanding that you have reached an agreement that I would give you a probation, but it is not agreed to the type of probation. Is that your understanding?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. White is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Ms. Holmes. She'll present it to me on your behalf when we come back. Did you have something?
Yes, Your Honor. I anticipate there will be at least one witness, a short witness at the sentencing.
Okay.
And a video as well, a short video. I don't know if we just need a little bit more time than ordinary.
Let's just, we'll do it at 11.
Okay.
That way, y'all have plenty of time.
Your Honor, since this is a probation offer, although we're agreed on the type, would the court consider reduction of bond?
State's opposed to that, Judge. The alleged weapon that was possessed by this defendant was outfitted with a Glock switch. Actually, I don't want to speak. I know it was outfitted with a Glock switch. I think there was also 2 weapons that was
involved in this entire occurrence?
Well, let's see. How old are you, Mr. White?
23. There were 2 weapons involved, one of which was outfitted with a belt switch, Judge.
Typically on a probation offer like this, I would be inclined to do that. However, with the type of offense and the age of Mr. White, there's the possibility, like I have been on a lot of these young ones, that I will consider something like ISF, depending on what that pre-sentence report shows. And based on that, at this time, I'm not going to reduce that bond. Okay, you can go back with the bailiff. On Segura, I'm printing a PC on that Wilkinson. And is there an order for the bond, for the? All right, are you Dylan Wilkinson? And Mr. Wilkinson is charged in cause number 250260 with deadly conduct, discharging a firearm. And Ms. Holmes has filed a motion asking that I reduce the bond, which is currently set at $100,000. There was a non-appearance, is that correct? A bond forfeiture for non-appearance.
And that's what we'll address here, because he bonded out in Smith County, so he actually did post a bond, but Jefferson County apparently didn't get word of it. So he was in custody in Smith County, posted bond, but still had the warrant here. And so when he came to Jefferson County, he was rearrested. And then it was set at 100,000.
But I show there was a bailiff's call. There was a court date set. Yeah, there was a court date set that on May 19th of 2025. There was a court date and a bailiff's call, and he was not here.
Per the bondsman, after I had spoken to her, she said, basically, she told me on the ISTC phones up there at the jail when I got arrested this time, she said that Jefferson County was highly pissed. I had gotten, I was able to make bail, and that for 4 months that they had not known that I was out on bail. And then she said I needed to take care of the stuff in Jefferson County, and that she was no longer my bail bondsman. And that was the last time I spoke to her.
She doesn't get to say that, so, but that's why you probably didn't get notice of it. This is from a Big Green Bail Bonds
That's the woman I had spoken to.
in Tyler.
Yeah.
Okay.
Because I wasn't sure why.
Yeah, that's Smith County.
I wasn't
Tyler,
exactly sure why I was rearrested again, and she never really could give me a straight answer.
And she never told you about a court date.
No. And you're saying I had a court date on what date you said?
May 19th.
That's when I had a court date.
What were you arrested for in Smith County?
The charge from here.
That's what he turned himself in
in Smith County, thinking he posted the bond,
Mm,
but
okay.
I don't know.
And the initial bond that they set, I guess, did
It was
they
only
set it or did I?
10,000.
They said it, they're.
That was 10,000. Let me read this real quick. They also did file an AFRS to get off the bond. But the bond forfeiture overrode that, so that might be why she. For everyone's information, I'm reviewing the probable cause affidavit, which obviously makes me have some concern on what the allegations are that you did. So where do you live?
I'm going to be staying with my mother.
With your mom?
Yes, ma'am.
Where's that?
One straight over for Brinkman Drive in PA.
In Port Arthur?
Yes, ma'am.
What is the address?
3965 13th Street.
3965 13.
And what is your mom's name?
Monica Osman.
What's the last name?
Osman, Ozmun.
Is there any criminal history that you know of?
There's a misdemeanor DWI conviction and a very extensive juvenile history from Henderson County.
Okay.
Several adjudications from unauthorized use of motor vehicle and burglary vehicle.
And I believe those were over 10 years ago.
It can't be that long ago because he's only,
He's 25.
okay.
I think they're
Yeah.
around 2015.
Okay.
And the complainant, is my understanding, she doesn't live here. She lives in the reports that state she lives around like the Dallas area, like Kemp, Texas, where is that? I think that's up near the Dallas area.
Okay.
There's two complainants.
Yeah.
Oh,
There's one here and one there.
Yes, Your Honor.
but the girlfriend lives up near the Dallas area.
Haley Murph.
Yes, ma'am.
When's the last time you had contact with her?
It's been at least 9 months to a year. I haven't spoken to her since well over last year. I don't know whereabouts on where she's at. Last time I heard anything, someone had told me that she was engaged and moving to Colorado.
Second. And do you know this Samantha Grant?
No, ma'am, I've never met her before.
Mr. Nichols, what's your position?
Whatever the court decides as far as the bond, I just ask it to be sufficient to make sure he appears. I'll let the court know there's some cooperation issues with the girlfriend of the victim, but I have seen nothing to concern the other victims, so I intend to push this case forward, Your Honor.
Okay. All right, so here's what I'm gonna do. Mr. Wilkinson, I'm going to grant the motion to reduce your bond. I'm going to reduce your bond to $30,000. If you make that bond, there are several important conditions of it. The first is that you have absolutely no contact, no communication in any way. That's obviously in person, but it also means through social media, sending messages through other people, anything like that, with either Haley Murph or Samantha Grant.
Yes, ma'am.
Also, you are going to be ordered as a condition of that bond to live with your mom, Monica Usman, at 3965 13th Street, and that is the only place you can live. You cannot move unless you ask my permission. You're also going to be required to wear a GPS monitoring device at all times and remain in Jefferson County unless you have my permission. Do you understand that as well?
Yes, ma'am.
All right, any other conditions or?
I think that'll do it, Your Honor. Thank you.
Okay, so he does have a job that requires travel, Your Honor. How would that work as far as, do we need to
I need
contact
this.
the court?
Yep. I want specific information about, you need to get that to Ms. Holmes. And so if you make that bond, a couple things will happen. One, if you make the bond, you need to know now that you will be required to at least try to hire your own lawyer. So that's something you'll need to keep in mind. Ms. Holmes will stay your lawyer unless that happens. But as soon as you get out, if you have a job that requires travel, you need to let her know, employer, get something in writing, where you go, things like that. She'll get it to me through a memo with Mr. Nichols involved in it, and then I'll say yes or no to that. You cannot leave unless you have my permission, so you've got to stay in touch with her. She gets to me, and then you'll see if you, and I mean, we want you working. I just need to know where and what the company is and all that kind of stuff. Okay?
Yes, ma'am.
All right, you can go back with the bailiff. All right, and so I'll just give you a minute to go visit with.
I'm going to fill something out for you. I just want to make sure that I'm incorporating everything, so I'm going to read this to you after I'm done writing it out, okay? I'm going to let the two of you take a look at this. There's a place for you to prove this on the second page and date it. For whatever reason, they have defendant's signature on the top. You're the principal of Trenton Auto Parts, right?
Yes, sir.
Okay, so you two go out in the hall or conference room, take a look, make sure this meets with your approval. If it does, sign the back of it, date the back of it where it says you're the defendant, obviously, and I'd like you to sign president or whatever your title is because it's a corporation, right?
It's a DBA.
Okay, well then you sign your name doing business as, okay?
Yep.
And then you would sign your regular name before anything else, before you leave, come on back in and we'll put it on record, okay?
Thank you, Your Honor.
Thank you, gentlemen. All right. Do I have Delaney Provencher versus Theron Parks? 2502156. You know what, folks? I'm sorry. I need to take 5 minutes. I will call your case first when I come out. Just give me 5 minutes. I'll be back out here. So just stay seated. Okay, can I, what's that? All right, on a real quick take, Synchrony Bank versus James G. Brammer, 2402978, and then, okay, counsel, your appearance?
Good morning, Your Honor. Andrew Cates, P78212 for Synchrony Bank.
Is Jocelyn Rose Huey out there?
I have not heard from Ms. Udy, nor have I heard from Mr. Brammer.
No, Your Honor, I don't have either.
How long you been practicing?
About 11 years now, sir.
If there's one thing that's changed in the 40 years I've been a lawyer is the number of lawyers that don't show up. I don't get it. And then judges are the bad guys when they enter a judgment. How can you miss this? They don't even have to get off their couch. I mean, they could be sitting in their patio doing these, and I still can't get them to show up. What do you want to do?
Your Honor, at this point, I would request a default.
Go ahead.
There were damages in this case of, I apologize, I was actually filling out my judgment as you were sitting. $5,581.57. And we are requesting court costs, which I was hoping to get a hold of the court file to see the service fee.
I have $20 in a motion fee. I have $75 in a filing fee. Let me see here if I have the proof of service. Do you have any indication what the what the service fee was, Jen? I don't have it here. You might have had two motion fees. It looks like you had two motion fees, $40. And you don't know what it is?
I don't have the proof of service with me, Your Honor. I apologize that I did not send that. I could waive the proof of service fee.
So you got 115 plus 5581 for a total of 56, 96, 57, right?
Plus the $75.
Right,
attorney fee.
right.
So
Thank
that'll
you.
be,
So 5771, 57, right?
Yes, Your Honor.
Those nuns pounded the figures, multiplication tables and division and adding and everything else into our brains. You're all set. Submit your judgment. Defendant failed to appear. Thank you very much.
Thank you, Your Honor.
What case do you have there, sir? What case do you have? What's your name?
Deontay Jones.
It's the Edward Rose and Associates, Judge.
Okay. Edward Rose and Associates versus the Landings Apartment.
Yes, sir.
And the Landings Apartments versus Michaela Manitak and Deontay Jones, 2403372. Okay. Now. Did you guys resolve this, counsel?
I haven't had an opportunity to speak with her. I'm happy to go outside and chat with her. As far as I know, there's a judgment against Deontay still. The order to set aside is only as to Michaela.
Why don't you two go out and see if you can't resolve this? Will you do that for me, please?
I will. Yes.
Thank you.
Give me a look.
Yes. Delaney Preventure versus Theron Parks. Counsel, which one do you have?
Your Honor,
Yeah.
me?
Yeah.
Oh, yes. It's S&D Investors, Your Honor, versus Ladrell Gardner, case number 2501355GC.
Okay, this one shouldn't be long. I'll come to you next, okay? Delaney Preventure doing business as Double D Construction LLC versus Theron Parks. Your name?
I'm Delaney Prevention.
Your name?
Karen Brooks.
All right, and who is this?
Karen Montgomery.
I'm sorry, what's your name?
Karen Montgomery.
Say that again?
Karen Montgomery.
Theron Montgomery. All right, now listen, you two, you need to keep your voice up, okay, for me, everybody, please? By proceeding in the small claims division, you're giving up certain rights. Each of you are giving up the right to appeal my decision. Each of you are giving up the right to hire a lawyer, to demand a trial by jury, and to the extent that you may be entitled to it, you're giving up the right to seek in excess of $7,000. Do you understand that, Ms. Preventure?
Yes, I do.
Do you understand that, Ms. Parks?
Yes.
You don't have to give up those rights. If you do choose to, you can have the case removed to the general civil division, in which case you can appeal my decision. You can hire a lawyer, demand a trial by jury, and to the extent that you're entitled to it, plaintiff, you can seek in excess of $7,000. Do you understand what I just said, Ms. Preventure?
Yes, I do.
Ms. Parks?
I do.
Do you wish to give up those rights and proceed here, Ms. Preventure?
Yes, I do.
Ms. Parks?
Yes.
All right, I'm going to ask all of you, including Ms. Montgomery, to raise your right hands. Do you solemnly swear or affirm? You solemnly swear or affirm under penalties of perjury that the testimony you'll give of these proceedings will be the whole truth. So help you God. Ms. Preventure?
Yes, sir.
Ms. Parks? Ms. Montgomery? Okay, nice and loud. You got to keep your voice up for me, okay? You're soft-spoken. All right. Defendant contracted at my company Build a Shed. She purchased for $1,000 plus the cost of fees and permits, which cost an additional $275. Defendant had hired a side contractor to pour concrete for the shed, which did not pass inspection, so I had to pay an additional $535 for the new concrete plus $400 additional labor to do the cleaning up and grading from the concrete being tore out and repoured. Is all of that true? Did you hire a contractor to pour concrete for the shed, and did it not pass inspection? True or false?
I did hire a contractor, yes. It was
Nice and loud, nice and loud.
I did hire a contractor that the plaintiff recommended.
Is that true?
We were asked if we knew if there was a concrete person, and that's the person that we gave her. She was free to go anywhere she wanted.
So the guy you recommended didn't do it right. Right?
The gentleman that we told her about did not do it right, but she was free to.
I know, I get it.
Okay.
Have you used him before?
No, he was someone that was used on other jobs that we had been on. So it was just a construction thing.
All right, you go ahead and tell me what you got to say, Ms. Parks.
Okay.
Nice and loud. You got to go a lot louder.
His name is Danny, I can't remember his last name.
Danny Palmer.
Danny Palmer.
Okay.
He recommended, because I asked him for a recommendation if he knew anyone. He gave me a guy named Mark. I don't know his last name. So he did the job, but apparently he didn't do the permits or something correctly. So he had to come back and redo it.
To my understanding, Mark redid it because I was at work.
Danny Palmer?
Yes,
And then tell me that again, you kind of lost me. Danny Palmer, you hired to do the work, right?
I hired him for the shed. He's a carpenter.
Okay,
And he recommended Mark, who has a company who does cement work. So Mark did the cement. He didn't get, I guess, the approval or whatever he was supposed to do, which was included in my estimate in the contract with him from me to Mark.
Mark what? What's his last name?
Danny Palmer works with me in double duties.
So I had the contract with Mark and it included the fees and Danny knew that. And I even have paper, I even printed out the text messages where Danny acknowledges, oh, well, I'll have to get these fees back from him because he knew they were included in the fees and everything for the units were included in my contract with Mark. And we had already agreed.
So somebody who worked for you recommended this Mark gentleman.
Danny Palmer
Right.
told her that
Mark.
this Mark, I don't even know Mark's last name, but he told her that Mark did concrete and got them in touch.
Okay.
And they took everything from there. I had nothing to do with the concrete until the inspection was denied because it was put too close, because it was put too close to the easement line. And so.
What city was this in?
Brownstown Township.
All right. So the inspection was denied, then what?
So it had, the inspector told me that
It had to be redone.
it had to be redone. And so that's what Danny told Ms. Parks. And so, it had to be redone, but the guy's like, I'm not doing it. We had nothing to do with contract.
Wait a minute, slow down. They said it had to be redone. Mark didn't want to redo it.
Mark didn't want to redo it. But, Danny told him, it's like, we've got to take care of this lady, okay?
Okay.
So, it ended up that the concrete had to be torn out. Once again.
Who did that work?
Mark came out and redid it,
Mark came out and took out the concrete
took out the concrete.
and he poured the cement?
But I had to pay for the concrete,
Okay.
okay?
Okay.
I had to pay for the concrete, I had to pay for getting the permit for the concrete because there was no permit pulled. And so I paid for the permit for the concrete, I paid for the concrete, I paid for cleanup, I paid other people.
Who did the concrete?
Mark did the concrete.
So Mark, who had referred, I see. So you still got Mark to come out and do it.
Yes, but I had to pay for the concrete because he said she hadn't paid him the first time.
Did you pay him?
Every penny. Yes, it was a $3,000 contract, and I paid him the $3,000. And Danny I printed out all the text messages from Danny, and one of them states, Mark would have to pay for the cement part and the permit and everything because he knew that I had already paid for everything. I took care of everything until the city sent me a notice saying that I'm gonna be fined $100 a day because they didn't do far enough off the easement. So they had to come back out. He had to come back out with it's called Mr. Crete, and all I had was Mark.
So you paid Mark $3,000.
Yes. And.
Hang on.
Oh, I'm sorry.
And you paid Mark again?
No, I didn't pay Mark, I just paid for the concrete for the second floor.
Well, you also paid for permit fees,
I also
right?
paid for the permit fee.
How much did you pay Mark?
I didn't pay Mark anything. I just paid for the concrete.
Well, I know, but how'd you pay for the concrete? Did you pay
I
through
paid-
your company or did you give it to Mark?
I paid for the concrete through my charge card.
Okay, how much was that?
It was $535 from Wallace Concrete.
And then you paid, hang on, and you paid the permit fees of how much?
I paid $75 for the permit for the concrete.
All right, so you had essentially out of pocket with regard to the concrete, you had $610. Is that true or false?
I'm gonna say yes because I don't have a calculator on top.
Well, 525, you had didn't you say
525 and 75.
I thought you said 535.
And 75.
That's 610.
Yes,
So you paid 610 out of pocket.
yes, sir.
Why should she have to pay that? She already paid the guy.
Okay. The thing of it is like,
And do you have any reason to dispute that she paid this guy?
me?
I'm asking you if you have any reason to dispute that she, the defendant, paid this guy.
Anything I can say would only be hearsay, Your Honor.
Well,
I don't know that she paid him. I don't know that she didn't pay him.
okay.
All I know.
Do you want
is
to go
what
call him up and find out if she paid him?
I don't even have a phone number for him.
Did he never told you that she paid him?
He told Dan Palmer that she didn't pay him.
He told Dan Palmer that she didn't
And
pay him.
Dan Palmer was here, but he had to leave to go to go work on a
Do you want
job.
to go have Dan Palmer log on to Zoom?
He had, oh, Your Honor, there's no technical gene in Dan Palmer, so no.
Okay.
He would not have any way of knowing how to do so.
And you're promising me, you're under oath.
I am under oath.
No, I'm looking at her now. I'm looking at her.
Oh, okay.
Okay. You're promising me, you're assuring me, Ms. Parks, that you paid Danny Palmer $3,000.
I paid.
Mark, I misspoke. Mark, $3,000, right?
Yes.
What are you looking for on your phone?
I'm trying to look and see if I have a check under my account, under my, in my, electronic payment thing, and see if I can just.
How much was the contract between you and Ms. Parks, Ms. Provencher?
We were going to charge $1,000 for for putting up the
Shed.
shed that she had purchased.
Did she
Plus-
pay you?
No, plus the additional fees of $250
For what?
for the permits and fees that were required for Brownstown.
For the concrete?
No, not for the concrete.
For the shed?
Alone, yes.
Okay. You agree that you at least owe her that, right?
I did, and I had a check for him the day he came for it. And I had also told him since January, I've been telling him, I need my receipt for the jobs he had done. And
Who are you talking about? Who's
Dan,
who? Okay.
he had broken a door, which I have a picture of. And I said, I still need that door fixed that you broke when you were installing it. He kept saying that he didn't have the receipt, he was in his car, his truck, then he said his wife had it. It was always since January, I can't get that receipt. I said, okay, please bring receipt, every time I talk to him, please bring receipts, please get me the door. Then I said, okay, make sure when you come to get the check, don't forget to bring the receipt for the door and the receipt for what I'm about to pay you now. He came there completely empty-handed, and I asked him, I said, well, where's the door and my receipts?
The door to the shed you're talking about?
No, the door for another job, but the receipt for this job.
This was something else. I'm only here for the shed.
So the receipt for this job, he refused to give me a receipt saying that I'm paying him and the door that he broke before. And I'm like,
what door?
All I want is the receipt.
Your Honor, he had done other work for her that was not part of this.
Okay, so that's between you and him, right?
Yes, but even the receipt for this job, I'm like, just give me the
But
receipt.
you agree that you were at least $1,250, right?
No, it was $11.75 because $75 the city of Brownstown said was for the concrete permit. I already paid for that through my
But I had
contract. That's not my fault. I paid for that through
Yeah,
my
but
contract.
this guy didn't work for her. the cement contractor did not work for her,
That's
right?
what she's saying. She repaid for a cement receipt that I already paid the cement contractor to pay for.
There was never a permit pulled on the concrete at all. If there had been, then the inspector would not have allowed them to set it back as far as they set it. It was too close to an easement.
Yeah.
I've got a copy of the plot.
How do you get to $2,210 on
That
this?
includes the concrete, when I had to pay to, do the grading and stuff after the.
Did she ever convey to you, Ms. Parks, ever convey to you that she'd already paid this gentleman the $3,000?
No, I never knew that.
Danny, I never spoken. This is the first time I've ever seen her, ever. Danny.
But Danny worked for you, right?
Danny works with me.
Did Danny come back and tell you $3,000?
No, Danny came back and said that she hadn't paid Mark anything. This was back in January when they weren't even supposed to pour anything.
And you assure me you paid $3,000?
Yes, yes, I definitely.
Now, he's your employee, though.
Who, Mark?
Yeah.
No, Mark is nothing.
Wait a minute, slow down. I'm sorry, I'm getting confused between the Mark and Danny. Mark,
Is nothing to me.
I know, Danny is your employee. And she assured Danny that she paid, she's saying she paid $3,000. She says she told Danny. Did you not tell me that?
I told Danny, yes, that I had paid him.
And did Danny ever convey that to you? He worked for you.
No, he did not, because I wasn't part of the concrete. He was just trying to work with her in getting her concrete done so that we could do the shed. That's the only thing we had to do with the concrete until I had to pay to report the concrete. And I had to get a permit to do it because there had never been.
You guys should have brought in this guy.
Her problem.
If Mark got his money, if Mark got his $3,000 and then you're paying for it, it sounds like he didn't lose anything other than the fact, I guess, he had to pour the concrete
He lost
second.
his reputation as far as I'm concerned, but no, as far as monetarily, he didn't lose anything. Your Honor, I would be perfectly happy if I could just collect for the shed and the permits that I paid for.
And that's $1,250, right?
I have also received the text messages that Danny even agreed that minus the $75, because I wrote it for $11.75 the check. Because, that would be.
I don't know why she isn't entitled to that.
And then the shed is already falling apart. When we had that wind, it blew off.
That's not our problem, sir. She bought the shed from Amazon.
You didn't put it together.
It was put
properly.
together per instructions.
That's not before me here.
But I have a copy of the letter that, from back in December, from the building department to Ms. Parks about the cement pad being in the backyard, being not in the right place and everything else. So she was aware of it, and she could have, she could have done anything she wanted to with Mark.
I told Mark, I told Danny that I was going to sue. Danny convinced me not to sue. He says, let me try and handle it, and I have that in the text. Let me try and handle it. We talk to Mark and see if we can come to some resolution. I never asked him to go and pay for things that I'd already paid for.
Like I said, Your Honor, I would be perfectly happy.
I know, and I think that's fair. Judgment is for plaintiff, $1,250. He also paid a filing fee of $88. Did you have any other out of pocket?
No, sir.
$1,338 is the total. You got to remember something. She really didn't have anything to do with that. She didn't hire the contractor. You did.
Yes.
I'm just telling you, this is fair. Can you pay her now?
I can pay, but I still don't get a receipt for it. I don't get the receipt.
Hang on, slow down. Slow down. Everybody slow down. Ma'am.
What you're saying, wait for me to finish.
If you pay her the check, that's a receipt. What do you need a receipt for?
Because
Do you have a check right now?
I can write the check.
Can you write her a receipt right now? Can you write her a receipt?
I'll write it right on this kind of.
Yeah, you guys, come on now. Let's not act like 9-year-olds here. You guys can figure that out. You're gonna pay by check. She's gonna write your receipt. I'm entering a judgment. You can go down the hall and take care of that. If there's any problem, you two come back here, okay?
Give me that number again, please.
$1,338. Because I'm charging filing fee. She's entitled to a filing fee. So it's $1,250 plus the 80. Okay? Thank you all.
Thank you, Your Honor.
All right, S&D versus Ladero Garner, 2501355.
Ready, Your Honor. Daniel Goman, 64231 for the plaintiff.
All right, is he here, Ladero Gardner?
I've not had him check in, Your Honor.
Counsel, I'll give you a default if you want.
I do, Your Honor. The amount of, I think we had a proposed judgment with our motion, Your Honor. Judgment for $2,810.72.
Well, so you filed a motion to strike his answer, right?
For a more definite, yeah, motion to strike or for a default, or in the alternative for a more definite statement. He gave us, Your Honor, a letter answer.
Yeah, I don't think I can really give you a judgment. He didn't show up on this. I can give you an order requiring a more definite answer if you want. Let me see here.
Well, Your Honor, we think, as our motion states, for what it's worth, that the answer was a failure to answer and therefore it's deemed admitted. We have a detailed complaint. He certainly has personal knowledge about whether he had these accounts or not. Instead, he gave us a letter answer, which I think he just Googled how to defend a credit claim and sent that to us. But it's very clear what the charges are. The complaint is detailed. He didn't answer. In the alternative, we've asked for a more definite statement within 7 days, or in the failure to do that, I would ask for default.
All right, yeah, I don't feel comfortable giving you a default. I'll give you an order requiring an amended answer. I'm gonna give him 21 days. And if he doesn't, then you can file your motion again and I'll grant your default, okay?
Thank you, Your Honor.
All right, thanks a lot. Have a good day. Sorry to keep you waiting.
Thank you, Your Honor.
Within 21 days, Jim.
Yes, Judge.
All right, now, JP Morgan versus Jokola. Did I call that one already?
No, Your Honor.
Danielle R. Jokola, JP Morgan Chase versus Danielle R. Jokola, 2403002. Anybody here on this one? Where's Danielle Jokola? Is she here?
No, Your Honor. It looks like there's no attorneys that have appeared. I will see if anything's been filed. Hold on one.
Was Mr. Royce here, or did I hold a pretrial? Did I do this one? It was set for bench trial today, Your Honor.
Okay, wait a second now. Sir, you're gonna have to control the child. I'm sorry, but you're gonna have to control the child, please.
Sorry.
Did I not call this one?
No, you didn't.
You did not, Your Honor, but it was set for bench trial today at 10, and it does not look like either parties appeared. We're checking to make sure nothing got filed at the last minute.
Was Mr. Royce not in here today? I thought he was in here on something.
They were here for JP Morgan Chase and Susan Swaffer at 8:30.
I don't know what to say anymore. You're sure I didn't call this case, right? Nobody showed for trial. It was scheduled for 10, right, Jen?
That's correct, Your Honor.
Case dismissed. All right, now, St. Louis. Ronald St. Louis. Oh, wait a minute. Let me get you guys out of here. Michael Phelps versus Trenton Auto Parts. Your name?
Michael Phelps.
Your name?
Richard Jazerski.
Can you hand that up? Did you guys sign it?
Yep.
Any problem with it?
No.
Hand it up, I'll sign it, and you'll go down the hall and you'll get a copy of the judgment.
One thing is though, just on, if we could, refund won't be processed until contacts his credit card company removing the chargeback.
How do you want me to word it? Refund?
Refund will be processed.
Hang on, slow down. Will be processed.
After chargeback is removed.
You agree to that, Mr. Phelps?
I do, Your Honor.
I'll add that. I did forget to put that in. My apologies. I'm gonna go ahead and sign the order. Everybody's satisfied with this, right?
Yes, Your Honor.
Yes, sir.
And you are? How many gold medals did you win again?
None, I would have.
Take care. Good luck. I know. I mean, I know. You gotta have a silly sense of humor sometimes. Ronald St. Louis versus Brian Marshall. Have a good day, guys.
Your Honor, if I may, back on the JP Morgan Chase and Jokella, Linda just looked at 8:30 this morning. They e-filed a stipulated dismissal, but a stipulated order.
Make sure you change that on the paperwork. Come on up
I
here.
will.
St. Louis versus Marshall.
Your Honor, Mr. Scanlon at 10:13 this morning filed an appearance and a demand and order for removal. He is on Zoom, but he's indicating he's on another court at the moment.
He's appearing for who?
For me, Your Honor.
Wait a minute. Turn that podium toward me, will you please? Toward me.
Turn it the other way.
What's your name, sir?
Ronald St. Louis.
And your name?
Brian Marshall.
Where's the demand for removal?
It was just e-filed at 10:13 this morning, so it's in your box, but you don't physically have it.
All right, guys. I didn't know, or I wouldn't have made you stay here. What's your name, sir?
Carlos Velasquez.
They have the right to have the case removed to the General Civil Division, Mr. St. Louis, and that's what they've done. So he's got a lawyer now, and you can hire a lawyer if you want. I'm just telling you can. They have the right to do it. This isn't my rule. I don't make rules. They have the right to do it. So you can if you want. I'm just telling you, now that it's not going to be in the small claims division, the proceeding becomes much more formal. You can hire a lawyer. You can demand a trial by jury. You could seek in excess of $7,000. If you think you can prove that you're entitled to it, and you can appeal my decision. Do you understand that?
I do.
So all I'm going to do is sign the demand for removal. We'll set it for a pretrial. We'll give his lawyer notice. You can hire one if you want.
So, on the tools that he's stolen from me and he's keeping, I can now go after him, which I didn't want to do. He's my stepson, and my ex-wife was his mother. It was explaining what was going on between him and his girlfriend. Criminal charges for theft.
Well, you do what you gotta, hang on,
Do I have the
Hang
right
on.
to do that?
you can do whatever you want. Go talk to the police if you think there's a theft here. Absolutely, but I'm not sending you over there saying to go
No,
file.
no, I just if I have the right to do that. That's all.
If there's a theft, you always have the right to file a criminal complaint.
Yep.
Okay?
Yep.
And we'll send this out. We'll give you a pretrial order, all right?
You got it. Thank you very much.
All right, good luck. All right, who's here on Edward Rose in Minnetonka and Jones? This is 2403372 GC.
Attorney Lee Melvin, Your Honor, P8373, appearing on behalf of the plaintiff.
Do I have the register of actions? Yes, I do. All right, wow, this has been going on a while.
Where's the podium?
So, your name, man. Sir, your name.
DLT Jones.
All right, counsel. What have we got here?
So this is scheduled for a bench trial, Your Honor.
I see that.
We did go in the hallway and talk. We didn't come to a resolution today. There was some new information that I hadn't received from the defendants. What we would ask today, and I think we both agree, is to adjourn and they can provide information to me I don't have.
I can't adjourn this very long. This case is old.
And this case was filed.
September.
Right, but we didn't get service until.
I'll adjourn it 1 month for trial, if that's what you guys want.
Yes, that's fine with us.
But I would ask that, any documents that they have be turned over to the plaintiff. Because.
I don't know anything about this case. It's for 144670. Is that the only thing this is up for today, is trial?
Yes. Yes.
Did you not say, or somebody say, that Deontay Jones had a default judgment entered
Yes.
against him?
There is a default judgment against Mr. Jones. We made a default request against, this men attack. The court ordered that be set aside.
Okay, so I gotta have my cases done within a year. I'm just telling everybody, all right? And these are not my rules. It's the Supreme Court, and that's what they tell me, or else I gotta go and report. I'm gonna adjourn this 1 month. Is everybody gonna be ready for trial then?
Yes.
Yes, I mean, the main reason that I would like to adjourn is she provide confirmation of payments that I don't have.
Okay, good enough. Give me a date like August the 20th or something, Jen.
26th at 10:30?
At 10:30, no more adjournments, okay, folks?
Yes, sir.
All right, that's it, August 26th at 10:30. I wish you both well. Thank you very much.
Thank you.
Have a wonderful day.
Thank you for your time, Your Honor.
Thank you very much. Okay, John, I'm sending down some Zarowski's advice or rights here.
I'll get them all matched up.
I think I've got everything down here. And I think that's it. Am I done?
Yes.
Yeah.
All right, thank you.
Your Honor's gonna send out a notice to appear, correct?
What's that?
A notice
With the court's assistance, we've come to an agreement. We agree that as of today, Ms. O'Day owes $381.67. She will pay that by paying $300 on or before July 30th. I think her plan is to pay on the 27th. She'll pay her August rent of $258 on or before August 15th, and she'll pay the remaining $81.67 on or before August 31st. And she'll pay her September rent on time. If she makes those 4 payments, as just stated on the record, no late fees will be added to her ledger. We'll do this with a conditional order of dismissal, and we all hope that the matter will remain dismissed.
That is correct, Your Honor.
All right. All right. What I will do is I'll mark this file conditionally dismissed, order to follow in 14 days.
We'll have
Thank
it
you.
in this week, I think.
Yeah, you'll get it in before then, but.
Yeah.
Okay?
Thank you,
Thank
Gail.
you.
Thank you, Ms. O'Day. You take care of yourself. New Park Ridge Apartments versus Precious Term.
James Singh for the plaintiff.
Jill Bauer here on behalf of Ms. Sherman, who is also present.
We don't have an agreement yet, but my client is willing to enter into a conditional order of dismissal. I haven't had a chance to talk about the terms with Ms. Bauer. So if we could set this for a trial, hopefully we'll have it resolved before then.
How much time do you want? My trial week. Pardon?
Next Tuesday available?
I can. The 22nd is not available. I'm on prison Sunday. My next trial date would be what?
The 30th.
The 30th of July.
I'm out of the state that day, Your Honor.
What about the 29th? Do I have that day?
No, sir, you do not.
I don't. Oh, that's right.
August 5th is the next Tuesday. I am available on.
August 5th.
Yeah, let me just double check that I believe.
I'm in Tennessee with Mrs. Fink, 6 children, 5 children-in-law, and 16 of the most beautiful babies anyone has ever seen.
So he's not available.
So you're not available.
That's right.
I'm available the entirety of August, so. August 12th.
It's a Tuesday.
In the afternoon.
No, I have yeah, you don't want to be, I think.
Well, Your Honor, we can do it the week of the 4th, and we'll just have someone else in my office handle the trial.
So non-jury trial will be, what date did you give me? August 5th, 2025, 9 a.m.
Thank you. All
All right, let's hope. Thank you, Mr. Chairman. Court does call the case of Strong Future Homes versus McFarland.
Jill Bauer on behalf of Ms. McFarland, who is also present.
Just a my appearance on the record. James Singh for the plaintiff.
All right. And this one, we were looking to adjourn and try to work this out, I think.
I think we'll be able to work it out. Ms. Bauer and Ms. McFarland made an offer. We need to go over the numbers and see if we can make it work, but it's possible.
Yes.
So pre-trial on the 5th,
On the
when we
5th,
have the trial scheduled.
Okay, yeah, that sounds good, Your Honor. And Ms. McFarland, her understanding is that Hawk has kept her case open.
open, okay.
Yeah, so I think,
So maybe if we hit during the beginning, if I do August 5th, other funding will.
well, if we can resolve it before the end of
Do you
the
want to do
month,
it
that
before
would
the end
be.
of the month? to
Well, I
save
mean,
that
we could
3,000?
resolve it before the end of the month,
Yeah,
right?
yeah.
Yeah,
We'll try to do it this week.
okay, okay.
Sounds good. August
Thank
5th,
you.
9 a.m. Thank you. Hamilton Crossing 2 versus Ashley Jordan.
Right.
Okay.
James Singh for the plaintiff.
Jill Bauer on behalf of Ms. Jordan, who is also present.
All right. Tried to resolve this matter. Apparently, this will be heading to trial. Jim. Do not have this. I have this as a bench trial, so. Set it for August 5th,
Okay.
2025, 9 a.m. for trial. All right. I hope the parties can try to work something out prior to that date.
Your Honor, I thought we were talking about Miss Jordan's case when we set the term and matter for a trial. I think that one would probably be better for a pretrial on the 5th.
Which one?
Miss
Terman.
Terman.
Okay, so I'll set this one for trial.
Yes, sir.
And then I'll reset Terman for a.
Yeah, I think.
Well, they were set for final settlement conference, so I'll just adjourn the final settlement.
Just to remind the court, Ms. Engen had suggested that we just put all these cases over today so that we had more time to work on them, but they weren't necessarily supposed to be final settlement conferences, although we've resolved quite a bit because we.
I said it that way.
Okay.
So,
Thank you, Your Honor.
all right,
Okay,
thank
thank
folks.
you.
Lori Anderson versus Armani Lyman. Bueno. On that side. State your names, please.
You're gonna be over.
State your name. All right. I reviewed everything in the file and just to try to resolve the matter if we can. Set it for a final settlement conference today to see if there's a resolution. Ms. Lyman,
Yes.
do you still wish to reside in the property?
Yes, last court date, she asked me to stay and I decided that I.
Pardon?
Last court date, she talked to me after the court asked me to stay, so I decided that I will stay.
Okay. And Ms. Anderson, where are you on this case?
I want to apologize for the top.
Pardon?
I want to apologize to you for over talking over.
It happens. All right.
I just hesitate because, I'm worried about the condition of the property. From the outside, there's already damage, and Ms. Lyman, has approximately $20,000 of damage on a prior property on Maplehurst, Mr. Fink told me about. So, I mean, I have a $500,000 property, I'm worried about it coming down with Ms. Lyman, since she has a prior history of damaging property.
Go ahead, Ms. Lyman.
Honestly, I feel like the little Fink situation on June 27th, he had contacted her.
I don't know what that means.
So I feel like that's a conflict of interest and we're here for 42 Court, not Maplehurst. So I don't see why that's being brought up, and for that was a small situation.
Hold on a second. I don't know anything about that. So that's not under my head. Let me ask you this. Has rent been paid and everything, or?
No, I have not.
All right,
She said she would put the 3,300 in escrow.
all right. Is that what you would do, ma'am?
Yes, I did say that, but our last court date, you said that $25 a day was excessive. I ended up paying that $25 a day last month, so I was asking if I could pay
$25 a day?
Yes, so I was asking, could I pay $3,000?
Well, there's gonna have to be a claim on that, but what's the monthly rent?
$3,000.
All right. So I won't give a discount on that. We'll figure it out, but you've agreed to put that into escrow? The 3,300? Put it to place $3,300. in escrow, and that's really for the month of July, correct? And then 3,300 per month thereafter. All right. Folks, just in terms of resolving, go ahead.
What I was about to say, because last month I ended up paying the $25 a day, so I ended up paying.
I hear you. You're about to repeat yourself. I will resolve that once we get to the end of everything.
Oh.
If it is indeed illegal, but I'll figure it out. Yes, ma'am.
Last time you said that I could get $100 for late fees for.
I'm not gonna deal with late fees, folks. All right now. I'm just not. I mean, the issue is that if there's gonna be an agreement that she'll stay, because you filed a termination case, we have to figure out what the terms of that will be. Yes,
I really don't want her to stay because I'm worried about damages to property.
okay, so didn't we just go through this? You guys had a conversation about her stay, right? There then becomes this issue regarding damages at other places. I don't know anything about that. You're worried about damages at the premises. So what I was going to suggest to the parties is this. Would you object, because actually I can order it in any event, but that she's permitted to do an inspection of the premises?
There's no damages to the property.
Okay. Yes.
There are, from the outside, there are already 3 damages. There's oil stains in the driveway. There's blinds and the blinds in the back have been damaged. The screen in the back has been damaged. So that's just what I can see on the outside damages, and that's probably.
Okay, does anybody listen to me? Because it would seem to me that the way to resolve this issue would be for you to be permitted to do an inspection of the premises. Yes.
Also, she would need to change the locks back because I didn't authorize her to change the locks.
What does that have to do with anything right now? Yeah.
I don't want to offend you.
What?
I'm trying not to offend you, so I don't want to.
I'm not easily offended, so go ahead.
I just, if she wanted to work something out, I would have to be able to talk to her and not the older woman. I mean, there has to be some communication between me and her and not me and this older woman. And she would have to abide by the terms of the lease. That's all I'm asking, sir. I would work things out.
Yes.
She keeps talking about an older woman when.
Okay, so first of all, stop, both of you. I don't know, we come so close and then you guys just start talking past each other about stuff that may in the end not mean a thing. So the first thing is, if her tenancy is going to be maintained, you got to get the 3,300 in escrow. You want to do an inspection of the premises. What date are you going to do the inspection? What date would you like to do the inspection?
This week.
All right, would you be available to let her in to do the inspection this week?
No, I have school and work for the rest of the week. Mandatory. Could we try for like next week?
Monday, next week. What's wrong with that day?
What time?
In the afternoon, Monday would work. I was just asking a question.
What's the question?
Did you, ask her to change the locks back?
No, she's gonna be there. I'm not gonna deal with that right now. Okay? What I'm gonna do is there's gonna be an inspection on the premises.
sir, you do not.
So there'll be an inspection of the premises on the 21st. 2025 at, will 2 p.m. work for you? Yes. 2 p.m. All right. Then I need you guys back on, I'm gonna move this to, when's my Hodgepodge block on the first?
3 p.m. Your Honor.
So then I want to see you guys August 1st, 2025 at 3 p.m. That'll be an in-person hearing. Back, we'll look at what the inspection is and how we can go forth with this tenancy.
If the rent is in escrow, how do I pay the mortgage with the rent in escrow?
Well, it's going to be an escrow. I'm not clear, ma'am. It's going to be placed in escrow at this point in time, and then we'll figure out what we do on the 1st. Okay? Anything else from either side? I'm almost afraid to ask.
Just, can I be able to call her on her phone and talk to her?
I don't know. Are you capable?
Yes, I.
Okay. Will that work for you?
Yes.
And you'll answer? Okay. That's resolved. Anything else? Great. We'll see you on the 1st. Thanks, folks. Is Burns up? Okay, let me see counsel on Burns and back, please. Huh?
Yes, Your Honor.
You don't want to see?
Yes, Your Honor. Of course, Your Honor. Wait, let me get my bag.
Wait.
Where there is domestic violence, attempting
I reached out to Ms. Fordyce and provided dates in July and August for mediation in this case. On June 9th, I heard back from her in an email wherein she stated that her client, Mr. Keith Davis, was working out of town and would not be back until October. That was a quote from her email. My client is working out of town and will not be back in until October. Therefore, we can't set and then ask if I would agree to set mediation via Zoom because Ms. Salinas does sometimes do it by Zoom. When I tried to get that done on June 12th, she emailed, and again, at that point in time, when I found out that her client was not even living in the marital residence, then I filed a motion for my client to be restored to the marital residence. Then on June 12th, I heard back when we were trying to do the mediation via Zoom, and she emailed me on June 12th stating that her client does not want to appear until after a September criminal trial. Salient factor being is that my client is charged with basically attempted murder of her husband, and that trial is set in September. So thus, I've tried to set mediation in this case. There is an underlying criminal case wherein my client is the alleged perpetrator along with the daughter. And so again, ultimately, we're either asking to fish or cut bait, either waive mediation or do it. And then that goes on to say that relying on a statement from counsel that her client was working out of town, we asked to be restored to the marital residence. On Sunday night, I received an email from counsel that said that she was mistaken, as I understand, that her client isn't out of town, that he's simply working overtime. So my motion to be restored to the home was based on the understanding that her client was not even here and unavailable for mediation. She's clarified that on Sunday. So I don't know, again, if he's in town, he's living in the home, that changes the perspective of my motion, because the basis of my motion was he just wasn't living there and the home was vacant.
I assume there are bond restrictions if your client's not to be around him.
Exactly. So, I mean, that's the point. My client is still under bond conditions. So if he's living in the home, it renders it moot. But I wanted the court to understand the purpose of my making the motion was I was advised by counsel that he was working out of town and wasn't even available to do mediation. So, trying to comply with both criminal court bond conditions and that we didn't want a home that is covered by homeowner's insurance to be sitting vacant and some damage happened to it and the insurance not cover because again, it's vacant and he's working out of town. So
My point, I guess the main issue then today is going to be whether or not we're going to do mediation or waive it and set it for.
no, she's never brought that up.
And I misunderstood when you said he was having a network, because work in Clarksville. We have spent an inordinate amount of time removing her items for her benefit to a storage room. And now we're finding out that she's forged his name on a lease in Nashville. So I don't understand. She asked me to forfeit a lease she signed in Nashville.
I think right now, the only issue before me is whether or not we're going to do mediation or set the case for trial without waiving mediation. That's the only thing. The motion that she had filed regarding residence is no longer applicable because she's back in town, apparently, from what I'm understanding. And so under the bond conditions, she can't be around it. It was really just narrowly, I understand both sides want to have their say, but the only real issue is whether or not mediation should occur. What's your position regarding that one issue?
Wait, but if she had reached out and asked that?
Well, mediation is required by local, I'm sorry for over talking. Mediation is required by local rule, but by statute it's waived or waivable in cases where there is domestic violence. Attempting to murder your husband is domestic violence. So we're going to waive mediation, allow you to assign a trial date if you and she want to work on a date. I don't know that Judge Turnbow would have any problems in hearing it without mediation, but I certainly think that waiving mediation is appropriate under the statute. So.
Well, and again, I think it's their it's their right. As again, like I said, I reached out to set mediation and they haven't asked to waive it. And that's why I filed the motion.
So we're just going to cross the board waive it.
Right.
Because it is involving domestic violence. So we'll waive the mediation. You two want to try to get with the clerk about a date for a hearing, then I'll be glad to let you do that.
Well, we need to determine whether or not, I think the criminal case, I don't represent her in the criminal case, but I think it is set for trial in September. Here. Yes, Your Honor. It's
The daughter's now been arrested twice. So I don't know what that's been.
well, my point in raising that is that the criminal case, we need it set probably after the criminal case so we could go on and get dates unless, and again, I don't represent her represent her on the criminal case. I certainly don't represent the daughter.
Really?
I just don't know. I became aware of it and I forwarded that to the district because the mother and daughter reside together in the department of Nashville. And it's come to my attention that the daughter has now been arrested twice more. I don't know if that'll affect the trial date for them.
Well, if it's the first setting, I can almost guarantee you it's likely to be continued based on those facts, but it's not my case to make that ruling. So I'll leave it to, if you want to go ahead and get a date in September or in October,
Well, I didn't know when the next, after the September date, I don't think we need to do it the month that the trial date is set, the criminal case is set. So
I'm here in November again.
so can you just give us a November date?
Yes, that would probably be changed. One of them in spaces, I'm just letting you know in advance, it probably won't go.
Well, November 17th.
I'm available then.
Pardon?
I'm available.
November 17th.
Thank
Obviously, that's subject to what happens in the criminal case.
Right.
Won't hurt my feelings.
Well, again,
Won't hurt my feelings if you have to continue it after the.
well, and again, the scenario being is both these parties want divorced. Of course, I don't think there's necessarily, given the posture, the alimony claim is, he works, my client doesn't, but I think the criminal situation limits my ability to request alimony. But again, it's going to
I
be,
would like to hear a case in which they.
well, again, selling it may be just the fact of getting the household and division of assets.
All right. Well, we're going to set it for that November 17th day. We'll let you through. Pass it later.
Thank you, Your Honor.
I have 2023 CD 19030 Matthew Quentin Smith versus Elizabeth Carol Neese Smith. And Mr. Brady Wilkerson, that's your case as well. And all right. Well, you're last on the docket, so we'll come back to you after we've dealt with these others. We'll move to yesterday's case. That was the motion to withdraw. All right. This is Matricia Gray versus Lewis Gray. We have a motion to withdraw.
Yes, Your Honor. Ms. Thornton filed a motion to withdraw and for an attorney's lien in the amount of $6,263.75 against any and all proceeds that might be awarded to the husband.
All right, Lewis Gray in the courtroom. No opposition to the motion. Motion to withdraw is granted, and the request for an attorney's lien is also. They'll need to submit an order. I have. All right, we're going back then to yesterday's hearing. Mr. Brady Wilkerson, I believe you were ready. Butler versus Butler. Come up. You have something to say? Didn't speak to anyone else. I'm going to talk with my assistant this morning. He said that he had not heard from anyone. What was the name of the assistant?
Community Bank. This is a possessory suit we filed this morning, but we gave advanced written notice to the defendants that we were filing the suit this morning and that we were going to seek an audience from Your Honor about an application for expedited writ of possession for 2 pieces of construction equipment. And per the statute, if they don't show pursuant to the letter notice to them, and we have proof of delivery, UPS proof of deliveries that I can leave with the court. But if Your Honor could just look at the matter and perhaps make a decision on whether the application's proper for expedited writ before the court today, I can leave it with you. My number is listed, but again, if your office doesn't have a record of it, I understand.
We don't have any record of your assistant supposedly contacting my office. So I don't know if they contacted one of the other judges, but.
Your Honor. Your
Pardon?
Honor. Your Honor,
Yes.
I did send an email to all the other judges' assistants and the clerks requesting the case name so I could research more thoroughly in my email as to whether I approve something like this, but I always copy the clerks when I approve anything to be added to the docket. So far, 2 of the other 3 judges' assistants have said they don't have an email in regards to this case. And I've not been able to find anything in my email.
So you have not spoken to anyone from the plaintiff's firm, is that correct?
My assistant, Your Honor, is Miss Elizabeth Gray. And again, what we try to do with these is normally what happens is the suit gets filed, the application would then at some point in the morning be presented to the chancellor. Your Honor could look at the verified complaint that's been filed in support of the application for expedited writ. But
Well, I'm just concerned about the fact that it's being represented that someone spoke to my office and set this up to be heard, and we don't have any knowledge of it. I just want to clarify, how that came to be and find out who it is that they talked to, and so that we can clarify that issue. If you want to leave your file with me, when I'm concluded with court, I'll take a look at it.
that would be fine, Your Honor. And you've got my information in the application, the bond, the writ of possession, and the order granting the writ are all attached. I can also leave for Your Honor these 3 proofs of delivery. Is that they had notice that we were going to be seeking this application today, Judge. Thank you, Your Honor.
All right, we're back on Butler versus Butler from yesterday. We're just ready to believe your client had just finished testifying. Is that correct? Do you have any other proof? Mr. Butler, this is your opportunity. The plaintiff has rested on their ground for divorce, and this is your opportunity to present any proof that you wish to. Do you want to testify? All right, are you chewing gum? All right, spit it out before you take the stand, if you will. You come up. Raise your right hand and be placed on the oath. Thank you. Have a seat. Make sure you speak up loudly enough for the recording equipment to pick you up, okay?
Yes, sir.
All right, this is, like I say, you are representing yourself, so this is your opportunity to tell me what, you can respond to the statements that she made under oath about what happened. You can testify about what you want me to do regarding the divorce, the property division, and any kind of custody arrangements.
Yes, sir. So, on the I guess we'll just go kind of going down a timeline like they did yesterday. So on the Mother's Day incident.
Let me ask you this question before we get started, and please bear with me. Do you have any pending criminal cases that are pending right now?
I do that I'm taking to trial, yes.
All right, you have a case that's pending?
Yes, sir.
And what kind of case is that?
I was at the hospital being treated for poison ivy. And she showed up there and saw my car.
I'm just asking you, what's the charge?
Oh, stalking.
All right, so you have a pending stalking charge.
Yes, sir.
All right, you need to understand, and it's my duty to inform you of your rights. Every person who is going to testify has a right under the Fifth Amendment of our Constitution to decline to answer questions or to offer testimony if those answers or that testimony might tend to incriminate them in criminal conduct. In other words, if you testify today and you're asked questions about the events that led to that stalking charge, then your answers could later be used against you, and a recording's being made of that, So it's available to the state, the district attorney's office to use that as evidence against you in that criminal case. Do you understand that?
Yes, sir. Thank you.
Do you understand, Ben, that if you can either refuse to answer questions about that by invoking your right under the Fifth Amendment to decline to testify. You can avoid testifying, on direct when you're telling me what it is. Just don't tell me anything about it. But Ms. Brady Wilkerson has the right to ask you questions about that. And she can ask you a question after question after question. And you either answer the question or state that you decline to answer that question under the Fifth Amendment. Do you understand that?
Yes, sir.
Right. I've advised you of those rights. You're representing yourself. What happens from here on out is on you. You understand that?
Yes, sir.
All right, then go. Do you have any other witnesses that you intend to call?
I don't.
All right, no other witnesses. All right. Then, Mr. Butler, I'm ready to hear from you.
Yes, sir. So going back to Mother's Day, 2024, that weekend, me and Aaron were kind of having an argument, and I didn't realize that this at the time. She had been coming off. She stopped taking her antidepressant medicines, and she was very emotional that weekend. And I didn't realize that weekend, and it wasn't until later. And there was multiple attempts of trying to reason and kind of talk her down, and we couldn't come to an agreement. So it was that Sunday, once I realized we couldn't work anything out, I decided to take my other two children home. So that way she was yelling a lot that weekend, and I didn't want them to be, I've been trying to hide them from that. And so I ended up taking them home early and dropped them off. And instead of going back home, I sat in the car for a bit, and I wrote in my journal, and then I went home to give everything time to cool off. Anyways, and so I did, and when I saw her, I approached her, and I tried to amend the situation, and she just didn't really want to talk to me. So again, I left. And then I came back about an hour later, 2 hours later, I can't remember exactly how long. And she was just yelling and screaming, and eventually it led to the cops being called. And I did get the body cam footage of that, if I'm able to submit that for evidence of that night. And Aaron is telling the cops that um, the cops had came out to our house again. It was the morning, we were set to go to Montgomery Bell State Park that morning. And, that morning I was trying to talk to Aaron, like, because there's been a lot of friction between the two of us. And we were supposed to go to the state park with our son. And I was trying to kind of ease the situation so it didn't feel so tenseful, especially for our son while we're there. And she was just very hostile and just didn't I was gonna say just I don't know, just kind of trying to like shut me down like at every angle and just trying to like make me feel wrong. And then so I just kind of went about my business, you know, doing my own thing throughout the house. And she was, you know, doing her thing. And and you know, there had been a lot of yelling. And so she was in the bathroom doing her makeup, and I approached her and I said, you mind if we talk? And at this moment, I was just kind of like slowly shutting the door. And she said, you're trapping me in here. You're trapping me in here. I said, no, I'm not. And I quickly opened the door and I quickly moved my body out of the way. Okay. And and I got out of the bathroom, and she calls the cops, and the cops come, and she tells them that I was false imprisonment to her, and I was keeping her against her will. And quickly the cop and the sergeant came out, and I got the body cam footage for that too. I would like to submit. And they quickly realized that she's trying to amp the situation up, which has been kind of like the theme. And so anyways,
So were you charged that night?
I was not charged, Your Honor. No, sir. You know, because they realized what was actually going on.
This thing, you can't tell what somebody realized, nor can you repeat what they said, because that's hearsay.
Yes, sir. So no, yeah.
Tell me what do you want to do about you have one child with this?
Yes, sir. So I do have one child with Aaron, and I do have two children with another. And I just would like to get 50% custody. Me and my son Ryan are very, very close.
You want 50, how many times have you been arrested?
Quite a bit, but
Can you count?
yes, sir. It's 1, 2, I think 3 times here, and then once.
Are you on probation right now?
Yes, sir.
How long?
For 1 to 2 years. I think one year for early termination, and then 2 years for the full term.
Right. And you think that despite the fact that you're on probation for criminal conduct, that you should have equal time, 50% of the time of your son's life?
I do, sir.
And right now, how often are you seeing your other children?
I'm not seeing them at all, Your Honor.
Why?
I don't know why. She blocked me and won't take my phone calls, and I've tried to ask her why. And she says, I'm not getting into that right now. And then about the same time they took my custody away here is when she did it there. And it was about right back to back.
So right now, how often are you seeing your child with Aaron?
I'm not at all. I dropped my son off at school, and we were 1 minute late, and I dropped him off in the car rider line. Miss Brady said I dropped him off behind the school yesterday, and it was we were 100% in the car rider lane, and he had to walk to the cafeteria door. And I sat there in the car rider lane and watched him go in the door. And I watched the door open and him go in. And they said that I left him there by himself, which I never did. And I emailed Miss Brady multiple times when it happened to tell her the situation. I think there was a case with DCF got involved, and they found no wrongdoing.
Well, an order that was entered by Judge Turnbow in June of this year, this last month, says that you are to have supervised parenting time on Thursday from 5 p.m. to 7 p.m. and Sundays from 5 p.m. to 7 p.m. at the Eden Center.
Yes, sir.
Have you been exercising that visitation?
Yes, sir, I have. When it first started, I did miss the initial visit. I wasn't realizing it was that beginning of that week. And I also had, a lot of work going on that week because I do work for myself. And so after that one, we did get established. And there was one time on Father's Day, I was there, and I was there a couple minutes early, and they told me to park around back because there was a pending order of protection. And I guess so I waited till like right at 5, and I started to walk up, and then there was one of her workers. I didn't realize it at the time, was walking out to her car and gets in her car and leaves literally right at 5 o'clock. And nobody answered the door, and they said I was late. And I know I wasn't late. I was there on time. I was there early, a few minutes early. And then, so since then, I've had a witness go with me there, just so that way, something like that were to happen again, I had somebody to witness it.
You were ordered by Judge Turnbow to take a 14-panel drug test.
Yes, sir.
Is that what you had yesterday?
Yes, sir.
You want to introduce that, you can get that. Yes, if you will, we respect that.
And me and Miss Brady did talk about the 14-panel drug test cost upwards of $600 to $800. And after speaking with Miss Brady, she agreed to a 10-panel.
Your Honor, just so you know that part of it, that is, myself, not.
So you have a 10-panel drug test. This is a hair follicle test.
Yes, sir. And it goes back 90 days.
All right, mark that as exhibit. But you were ordered to take a 14-panel and you have not done it.
Well, I asked Miss Brady, because the 14-panel costs so much, if a 10-panel would be equal to the same as, because I was agreeable to a 14-panel, and they agreed to a 10-panel would be sufficient.
I'm not the one who ordered the 14-panel, that's the problem. Right. So if you're not seeing your children except for supervised visitation,
Yes.
and your child here from with Ms. Butler, you're seeing that child by supervised visitation, but you've not been exercising the supervised visitation, or you have?
I have, yes, sir, I have.
And that's at the Eden Center?
Yes, sir.
All right,
I've missed a couple of visits.
all right. And are you paying for that?
They said it's free there.
It is free. Okay. All right. Tell me what else you want me to do in this particular case.
So Judge Turnbow, they took away my custody. She made claims of me being on drugs, and I absolutely haven't been on drugs. For probation, they drug test me pretty regular, and then I also see a doctor once a month, and I get drug tested there. And I've been seeing him for multiple years, and I've never failed a drug test there. And so I guess there was an ex parte. They were to suspend my parenting time based on that right there, dropping my son off at school and just saying I was on drugs with no evidence or no, anything.
You heard your wife testify yesterday about some of the things that happened between the two of you and what she detailed as physical abuse that you've inflicted on her.
Yes, sir.
And she introduced photographs of bruises and on her face and bruises on her arm. And there was this testimony about you trying to gouge your eyes out with her thumbs and so forth. Do you understand how that can concern me regarding you as a custodian for your children?
Yes, sir, I do. And I never intended to gouge her eyeballs out or anything. And I hope you would take into consideration, Your Honor, that night she did come after me a few times, and I left and ran out to the back door and tried to leave the situation multiple times. And also she's had plenty of time to think about what to say, because it was months and months later before she even went to the police. And I did do complete the anger management 26-week class, Your Honor. I did go to Cumberland Heights intensive outpatient program. And I also have been involved with individual counseling for well over a year. When I was working at YRC Freight before they filed for bankruptcy, that's how I lost my job. My insurance provided 1 week free counseling every week, and I took advantage of that. And that's honestly, Your Honor, what has helped me grow as a person and change my outlook and help me control my emotions and also be a better parent to my son. And also, going to the outpatient, I haven't drank alcohol in been a while. I can't tell you exactly how long, but it's been multiple years. And I hope with that, Your Honor, I have, and I've also coached my son's soccer team, and all the kids on his team loved me. Every time I would show up for soccer practice, they would run over and jump on me. And I've been actively involved in my son's life in a positive manner, with anything and everything he had going on. I was sure to be there. And there was couple of times when Aaron's mother wanted to be involved, and she wasn't a big fan of me, and I always supported my son's relationship with his grandmother. And I've always made sure to tell Aaron that, if Gigi wants to come, I'll go somewhere else for a while. That way she can be involved as well. And so I'm also very supportive of everybody else being involved. And I'm a firm believer, the more people that love my son, the better.
Okay. Anything else?
Back in December, with that agreed order, when I was to get my son, and just I was there to get him, and pretty much every time, and except for there was one time I was doing a job in Georgia, and I had broke down on the side of the road. And it was my day to get Ryan from school, and I couldn't call Aaron to let her know that I was broke down. And I called the school multiple times. I called the daycare multiple times, no answer, left voicemail. And I ended up calling a friend of mine to go to the school to pick him up. and she went there and there was nobody there, she said. And that was, can't remember the exact date. It was, can't remember. But I think they did mention it yesterday, along with the, on the 7th, when we switched weekends. She said I didn't show up, even though I tried calling Miss Butler to confirm, and no answer. And then also, with my other two children, Your Honor, when me and their mother split, we decided on a child support. We never went to court for a while, and I've always paid her on time, and I always got my other two children when we're supposed to. We worked things out fine, and it wasn't till, I don't know, a couple years later till we finally went to court, and I had always paid her before without even a court order, and I took care of my children and got them every single weekend I was supposed to. I'm sure there was a couple times where I did miss, and because it had been many years because of something happened or being out of town or what have you, but I've been actively involved in all my children's life and as much as possible.
All right, anything else?
I'm sure there's something I'm missing, and I just hope the courts can see that.
All right, Mr. Brady, you have questions? You'll turn that phone
Oh,
in. Wait a minute, he started something else.
about the, I thought you meant like about the children, like with the stuff at the house. Your Honor, I don't ask for anything that's not mine. I don't want her retirement. I don't want anything that's not mine, and I would never ask for that. And the only things I would ask for is just that things get split equally. And, because
When you say split things equally, what specifically are you referring to?
such as in sale of the house, just like my personal property.
You want to sell the house and you want half the proceeds, is that correct?
Yes, sir, I would. And I have made several attempts to, in the beginning, to try to give Erin money. We did have a joint account, and I told her on multiple times that I was leaving money in there for her. And then one time, she did go up there, and she still is on the account. And I guess she tried to close the account. I'm not sure, but and so when I left the house, I didn't have a job, Your Honor, and I had been working for myself, and me and Erin came to an agreement that she was starting a new job.
Where are you working?
I'm working for myself right now, Your Honor, but I am looking for active employment.
All right. So when you say you're working for yourself, what do you do?
Diesel mechanic. I work on cars. And then I was doing a little bit of subcontracting in the beginning, but I since went back to just working on
How
cars.
long has it been since you had a steady job?
It's been about a year and a half, 2 years.
Is that when all these criminal cases started up?
Yeah, it's really hard.
So right now, what is your monthly income?
Oh, Your Honor, it varies. It could be $500 a week to like $200 a week.
Where are you living?
I'm living, a friend of mine helped me out because I was about to be homeless, and he allowed me to stay in a house that he has and that's empty to help me get back on my feet. It's not a permanent solution. It's that so I can get a job, find a place to live, and you know, that way I didn't have to live on the streets. So that's where I'm living at as of right now. And I am looking for a place and a job. There was a couple of job opportunities that had come up.
What do you have at the house that you're claiming is your personal property that you haven't been able to recover?
Yes, Your Honor. I would like to get Bailey and Corey as my other two children. Their stuff that's in the house, like their bed, their clothes, their personal stuff, toys, if I'm allowed. And their like sports equipment as well. So some of the stuff in the garage, like that may be theirs. I got toolboxes in the garage that I brought into this marriage that I had before, that I would like to get, and some tools in that garage I would like to get that I brought into the marriage, especially like my grandfather's tools. There are some tools that I did buy during the marriage, and you know, if we gotta, you know, split, however, I'm fine with that. There is also a lift in the garage. It's not set up, it's laying down. It's a car lift that it's not mine, it's a friend of mine's. I definitely would like to get that as well. And just stuff like that, you know, and I hope you take into consideration, Your Honor, that I pretty much had to start over, and I can barely afford to pay rent or on my own, let alone, you know, pay a double rent. And I did make several attempts to try to come up with a way to give her money, or you know, like that.
So have you been paying any kind of support to your wife?
And there was times where I tried to, and she wouldn't take it.
Have you been paying any support for your other two children?
Yes, sir.
And
I did miss a few payments, Your Honor. I did. But before then, I'd hardly missed a payment until recently. Times have gotten pretty hard. And I just been trying to do the best I can. Especially with, you know, like attorneys and all the fees, and I paid the probation, and it just completely drained everything. I also, leading up to this too, there was an inheritance that I got, and that I did give Erin $5,000 cash to pay her credit card.
When did you do that?
It was a few months before I left the house. So I hope you take that into consideration. I also, in the kitchen where we were going to put the archway, I drywalled that whole wall. I bought a bunch of drywall. I just bought a brand new refrigerator. It's on my credit card, which I'm fine to keep credit cards. You know, my debt's my debt. You know, her debt's her debt. I bought a bunch of baseboards, painted the hallway, painted the kitchen. Just did a bunch of work on the house. Bought new light fixtures for the kitchen. 2 light fixtures, and they were like $400 or $500 a piece.
Anything else?
Yeah. And then the mattress in our master bedroom I bought too. It was like $6,000 that I bought, and I did buy that during the marriage, and so I know that would have to get kind of split. And so YRC, my job, I worked for 10 years, and they filed for bankruptcy. And so I never quit my job, Your Honor. Due to them file for bankruptcy, I did lose my job. I was getting
Well, your wife testified, I think it was, that she thought you could make $25 an hour or more.
Yes, sir. Yeah, I think it's like $24 an hour. Yeah.
And that was the last job you had
Yes, sir. And then once they did that, me and her came to an agreement that, I would try to work for myself, especially with Ryan starting school. That way I can get him to and from school. And that way she could start her new job with no worries. And that's when, right before everything's happened. Yes, sir.
All right,
And,
anything else? All right, Ms. Brady, have you allowed to ask you some questions? And Ms. Brady, you may cross-examine.
Mr. Butler, I just have a couple of questions. So when the judge asked you how many times you've been arrested, do you know that it's been 7 times that you've been arrested, 7 different incidences?
yeah, I didn't realize it was that many times.
And- Go ahead. So, you were arrested January 17th of 2023 for aggravated domestic assault and false imprisonment. You were arrested May 13th, 2024 for violation of bond and resisting arrest. Does that sound right?
Yeah, I'm sure.
And then August the 10th, you were arrested for stalking and violation of bond. August 14th, aggravated stalking and use of electronic device. August 15th, aggravated stalking. And then most recently in May, on May 6th, you were arrested for violation of bond conditions in Cheatham County. And then on May 14th, arrested for reckless driving and aggravated stalking in Davidson County. So this has been going on now for 2 years, over 2 years. It started December of 2022 and has continued until just a couple months ago of a continual pattern of you being arrested because of things that you are doing to Miss Butler. Is that right?
Yeah, it's definitely being arrested sounds right, but being at a place where she shows up and me being arrested for never seeing her, and never even seeing her, I'm being arrested for, and it's been a constant attack on me since the beginning, a constant to try to have me arrested over and over and over. And there's body cam footage of that, a proof of that where.
Okay, and you have several convictions though as well. It's not just being arrested.
Yes, ma'am. I did make the mistake of taking the charge. My attorney was arguing with me that day, and they ended up kicking us out of the courtroom because he was yelling at me to take the charges.
Who was your lawyer?
It was attorney Nash. I gave him $10,000 that day, Your Honor, and I would never give him $10,000 to take a deal in one day.
So I want to ask you though, just to be clear, September 4th, 2024, you entered a plea and you were convicted of stalking, bond violation, and domestic violence.
I did take that deal, and I hadn't seen my son for months, and that's one of the reasons that I did want to take the deal, and so yeah, I ended up taking the deal because I was beat up over and over by attorney Nash, and I've made several attempts after that to appeal or put something in to take it back because I wasn't emotionally, I was unstable. He's over here attacking me to take this deal, and I ended up doing it. And so.
All right. And then here in May of 2025, you were found guilty. You didn't enter a plea, but you were found guilty by the court in Davidson County.
Yeah, and I don't know why the attorney, I told him, and I've got the the audio recording of when I met with him right before we talked to the judge, that we were to take all these charges to trial. And for whatever reason, one of them he set for a bench trial. And he told me that we weren't, nothing was going to be decided today. Everything was going to get bound over. And at the very end,
the judge said I was found guilty of, violation. And, you know, I had like my evidence and stuff. I didn't give at any of it at all. I didn't bring it because I wasn't under the impression that everything was going to get bound over the way he had told me from the beginning.
All right. And then I want to ask you a couple of other questions about where you're staying right now. Where are you staying? Where do you sleep at night?
Can I just clarify one thing from the question before? I did file an appeal to freeze the verdict, a motion, and I'm trying to take that one back and make all three of them go to trial because.
Okay. So where do you stay at night?
Yes, ma'am. I was staying right now in Pegram. There's a friend of mine that I do a little bit of work for, and he also gets a little bit of work from me. His name is Terry, and he has a house in the back of his house, and he said I could stay there till I can get on my feet. Or
Okay. And what's Terry's last name?
Whittle.
And did he happen to come with you today?
No, ma'am.
And in this house that you're staying in the back of his house, how big is it? What's it look like? How many rooms are there?
It's a 2-bedroom, 2-bath, 2-story. It's a pretty big house. I do have pictures of it I can submit for evidence.
And in this 2-bedroom house, does it have electricity?
Yes, it has electricity and it has water. It's in his name because he knows that I'm having a hard time and he's just trying to help me out.
Does it have flooring? Does it have carpet? What's on the floor?
Yeah, yes, ma'am. It's tile. They just recently remodeled the house a few years back.
Is this the house that DCS visited?
Yeah.
And you haven't gotten a copy of the DCS report or anything like that, is that right?
No,
Do you have a written lease for this place?
I do not.
You have an oral agreement though?
Yeah, it's just a verbal agreement, yes.
And what are you paying for rent each month?
I'm not paying him anything for rent each month.
And he lives near this home,
Yes.
like on the same property?
Kind of. They are separate properties. I'm sure they're separate properties, but he owns that property as well.
Okay. And you've had visits with Ryan since the June 4th hearing at the Eden Center.
Yeah.
And you missed 2 of them with no explanation. And you were late for 2 of them, is that right?
I don't recall that. I was late that one time. I was thinking it was at 5:30. I was also, I hadn't seen him in a while and it was hard to see him.
Okay. And I know today you brought someone with you. Who did you bring with you?
Yeah, that's Barbara.
And what's Miss Barbara's last name?
I think it's Whittle. Actually, I think it's different. I'm not sure.
Okay. And who is she? How do you know her?
That's Terry Whittle's mother. And I know her from church.
And does she live in the same community in Pegram?
Yes.
Does she live on the same property?
Her property's separate, but all these properties butt up together.
And she's come with you to some visits at the Eden Center?
Yes, ma'am. Since the on Father's Day when I was there, since that happened, and then also the Cheatham County Police have been pulling me over constantly, and for that too, so that way that couldn't happen.
Okay. And so, but she's come with you to those visits. So your son knows her.
Yeah. Yeah.
And your Miss Butler has agreed to allow her to be at those visits.
Yes.
And you think that Miss Barbara is a good person to be around your child?
I do, as far as I know, yes.
So if the court decided today that you were going to have, when you had parenting time with Ryan, if the court decided today that it would be with Miss Barbara present, how would that work for you? Do you think that would be acceptable?
Yeah, I think so.
All right, so then, on really the couple last little things, on the financial portion of this hearing, you said that you've made deposits into the joint account to try to help carry the cost of some of the home. Is that what, that was your testimony?
Yeah, well, in turn, I told Aaron that I had extra funds in there to let her know there was money, to try to, but she was never taking the money out of there.
And so if we looked at bank records and it looked like you had deposited $8,574, think that sounds right?
Probably. Yeah, but also a lot of that money was for like the parts or it wasn't 100% profit, I should say. It was for like material costs, that's bound in there as well.
I gotcha. And so if that same bank record would show that you deposited $8,500, but you withdrew $8,600 for child support, gas station, food purchases, do you think that sounds about accurate?
Sure.
All right, Your Honor, that's all I would have.
Also, Your Honor, Judge Turnbow, after the drug test results, he said that I could resume back to the 50% custody that we had before. If that was,
Well, I'm not Judge Turnbow.
I know, you're not, but
The criminal, you're on 2 years probation and your 1 year probation. Are those running concurrently at the same time?
yes, sir.
Is that here out of Cheatham County?
Yes, sir.
And have they filed a probation violation against you because of this new case?
Yes, sir.
And when is it set to be heard?
In August the 13th. I've
So-
also, the Cheatham County, the August the 13th.
You understand that with a probation
Yes.
violation, if the judge in August finds you guilty, they can revoke that 2 year sentence and you can go to prison for 2 years.
Yes, sir, I do. And I just really hope they don't, and I was,
I'm sure you do, but I'm just telling you, I'm making sure that you understand what's going on.
yes,
All
sir.
right,
And
thank you can step down. You have any other witnesses? I believe that's rest of his proof. Ms. Brady Wilkerson, do you wish to offer any other testimony? We're here in closing.
Your Honor, as you can see from the court file and as you've heard in testimony today, father's parenting time was set to be supervised June 4th by order of this court, and that it would be reviewed on June 30th if the father had completed a hair follicle, which it was announced, or it was ordered that it be a 14 panel. And then also that he had a DCS walkthrough of his home. Then the court reviewed that on June 30th, and on June 30th, in agreement with Judge Turnbow, that was reduced to a 10 panel because it had not been done by June 30th. The drug test hadn't been done. And so that was reduced to a 10 panel. We've got that today, which shows a negative screen. But other than that, nothing has changed in Mr. Butler's situation since June the 4th. And so I would ask the court that he be left at supervised visits. There's been no showing, no proof before the court that the home that he's in is stable. We have his testimony, but I would ask the court not to consider his testimony credible because he often doesn't even remember different things that have happened to him in his life. So, however, though, Your Honor, we would ask for a change of the schedule. As you know, it's 2 days a week at a facility, and that's not sustainable for a long-term situation. I've talked to my client, and she is agreeable, if the court is agreeable, to allow Barbara, if she's agreeable, to supervise that visit or supervise that parenting time. I know that's a little unusual since we don't really have her as, as a party or under an order of this court to do that, but that's something that we might consider, or we could say supervised by an agreeable third party, whoever that may be. However, that's going to be complicated because there's no contact between the parents right now based on the criminal case. So I'm not sure how to solve that problem for Mr. Butler, unfortunately. So there's that, but I want to go through, and I know you know this already, but I would just like to make it for the court's consideration, the factors in TCA 36-6106 that the court must consider. Obviously, strength, nature, and stability of the child's relationship with each parent. Prior to separation, there was a good relationship between both parents and the child. However, since then, there's been months where the father has been unwilling or unable to attend to Ryan's daily needs. He was either incarcerated, on the run from the police, or unavailable, didn't have a home. And so we would say that that factor weighs in favor of the mother. Second factor, each parent's past and potential for future performance of parenting responsibilities. As stated, Mr. Butler has struggled to fulfill these responsibilities. He's failed to pick up Ryan from school, dropped him off at the wrong places, and failed to maintain a stable home or job. So this factor weighs in favor of the mother. Number 3, refusal to attend court-ordered seminar is not applicable in this case. Number 4, the disposition of each parent to provide the child with food, clothing, medical care, education, and other necessary care. As you heard Ms. Butler testify, Mr. Butler has, actually, Your Honor, we didn't discuss that. Mr. Butler has not provided evidence of stable income at this point. At the hearing with Judge Turnbow, he didn't know the name of his landlord, didn't know how much rent he was paying. He had no information about his home. We have his testimony today that may have improved, but we don't have anything firm before the court other than his assurance that the home that he's in is acceptable. The mother, on the other hand, as you know, has maintained the home despite having no financial assistance or physical assistance from Mr. Butler. She has a job and has cared for the child. Therefore, that factor weighs in favor of the mother. The degree to which a parent has been the primary caregiver. We've already covered this. As you know, the mother has been the primary caregiver since at least July of 2024, when the father was court ordered to leave the home because of his own behavior, except for the times when the father was exercising parenting time every other weekend, which was very sporadic. And even those periods were marked by failed pickups or problematic drop-offs. So this factor weighs in favor of the mother. Number 6, the love, affection, and emotional ties. There's no doubt that Ryan loves both parents, so that factor weighs equally for both of them. Number 7, the emotional needs of the child and his developmental level. Obviously, a child needs stable relationships to be able to develop appropriately. In a home and a relationship that is marked by extreme domestic violence, stalking, and repeated failure to follow a court order, this preponderates in favor of the mother. The moral, physical, and emotional fitness of each parent. Again, there's deep concerns about the father's fitness and his ability to parent the child. Therefore, we would say this weighs in favor of the mother. Number 9 is the child's interactions with siblings, as well as involvement with physical surroundings and schools. As you heard, the mother has continued to facilitate a relationship between Ryan and his siblings that are not even her own children. Therefore, we would say that this factor weighs in favor of the mother. Importance of continuity in the child's life. You heard that he's been in the primary care of the mother for at least a year. And prior to that, even then, the mother was the stabilizing factor in her life. She's maintained a job, maintained a home, and all of these things while the father, as we know, has had his struggles. Number 11, evidence of physical or emotional abuse to the child, the other parent, or any other person. This has gone on and on and on for 3 years. So we say that this factor obviously weighs in favor of the mother. The character and behavior of any other person who resides in the home. No one lives with the mother. The father has lived in various homes. He's been in this place for at least 30 days. We hope that he stays there, but we don't know anything about who may be in or out of that home. So we say this factor weighs in favor of the mother. Number 13 does not apply. Number 14, each parent's employment schedule. Obviously, we don't have any evidence of the father's work schedule. This factor may honestly be equal between the two of them because it sounds like Mr. Butler has some flexibility in his schedule. And that, Your Honor, would be all that we would have on that. As far as the child support calculation, we've submitted evidence of what the credit should be to the mother, what her income is, what we believe his income should be if he worked the job that he were able to work. And we would ask that you accept all of that testimony as credible and make that an order of the court.
You've asked me to assign an income to him that clearly he's not earning at the present time. That would more or less be setting him up to fail, wouldn't it?
Your Honor, I'm sorry to say that I think that our position would be he has the ability to earn that. He's choosing not to earn it that's a different story. And that's what he has been able to historically earn. And that's what he agrees that he has the ability to earn. Whether he keeps a job or doesn't keep a job, child support court runs all day long on that exact same story. So that's our position on that. As far as the marital estate, the mother already testified that she's fine to divide the contents. That makes sense, of course, to sell the home, to close the joint account, that her retirement would be her own. They keep their own vehicles, they keep their respective debt. And again, Your Honor, we're renewing our request that the father be responsible for the mother's attorney's fees, or at least a significant portion of that, because many of these hearings and many of the things that we've done for the last 2 years is a direct result of his criminal behavior. And the mother shouldn't have to suffer that. Thank you.
Butler, you want to make a last statement?
Yes, sir. Yes, Your Honor. So the drug test was court ordered to be before the 30th, Your Honor. And I did have the drug test done before the 30th. And we just didn't have the results. Miss Brady did say I didn't have it done. I did. We just didn't have the results. And I showed the courts the receipts of the drug test, multiple receipts where I paid for it. And I've always been willing to get my son Ryan. It's been a constant attack for little things, nitpicky things. And that's just how it's been on me since day one. And I've always made a good faith effort to work with Aaron. I have provided, because I did start over, so I had to buy my kids all new clothes, all new cups, all new toys, all new everything. And I slowly have been building that stuff up because she's made it a challenge for me to go to the house. They did take out an order of protection on me, not because of violence. There has been no violence since the original incident in 2022. I can't remember the exact year, Your Honor. And since then, I have been in individual therapy for a number of years. I did do the domestic intervention for 26 weeks, and I ended up going back there because I just like the counselors for individual therapy with them as well. I know I don't have a stable income, Your Honor, and I hope the courts would take into consideration that me and Mrs. Butler had a verbal agreement beforehand to not seek active employment, because of everything going on. And then I also took these charges, and I didn't realize how hard it would be to get a job after that. And it's been incredibly difficult. And so in December, there was an agreed order that I was to have access to the outbuilding. There is a shop at our house where I have a lot of my tools. I did a lot of my work there to make my money, that I was allowed access there, and never once was I allowed to go back there after several attempts of trying to do that, Your Honor. And then when they did take the bracelet off me, it was not even days later. They went and put that order of protection on me for nothing. And then the first court date for the temporary, she didn't show up, and they were quickly trying to put things off. And so when I did get, it was like 40-something% custody in December. There was one time I couldn't get my son, and I did call somebody to go to the school to pick him up, and she said he wasn't even there. And so, because I couldn't call her because of the order of protection. And so, there was just that one time, and when I did drop my son, I want to make note of, Miss Brady saying that I dropped my son off in the back of the school. That was never a thing, and I've tried clearing the air on that since day one. And it was never in the back of the school. It was in the car rider line. And I know that she's been the primary custodian, but that's only because the false allegations of me being on drugs, they took away my custody, and I dropped my son off at school in the car rider lane and watched him go to the cafeteria. I watched him, and for that reason, I lost my custody. And I've been trying to get a discovery out of them for a very, very, very long time. I've had my discovery done last October, and they didn't turn theirs in until recently after filing for motion to compel, of a bunch of motions. And I want Your Honor, sucked a lot of the money out of me. And that's why I'm here today by myself. I know. So that's all I got. Thank you.
All right, we're gonna take our mid-morning recess. When I come back, I'll give you my room.
All right.
Hey, Mark, are y'all done? You see, this. Did he just take a break or is he thinking about it? Okay, well, we just need to just talk to him, so he was just taking a break. Yeah, no. Then we were gonna go back. If y'all finished, if he was thinking back and through. Please. Please. Let me go. Let me go. Let me go. That.
I have considered all of the evidence in this case and the exhibits that have been made, and will make the following ruling. Clearly, in this case, the evidence warrants awarding Mrs. Butler an absolute divorce on the grounds of inappropriate marital conduct. Proof has been overwhelming that she has been subjected to physical and emotional abuse. The physical violence towards her clearly resulted in criminal charges against Mr. Butler, and I'll deal with some of that a little later. But she is awarded an absolute divorce. That leads me then to the adoption of a parenting plan. As Ms. Brady has gone through them, I'll not belabor them, but I have considered all of the factors set forth in Tennessee Code Annotated 36-6106 regarding the adoption of a parenting plan and designation of the primary residential parent. The first factor favors the mother, the strength, nature, and stability of the child's relationship with each parent. Clearly, Mrs. Butler has been the primary parent all along, but Mr. Butler's issues with having criminal charges against him and having supervised visitation currently are such that I cannot find that that factor is even equal. It must be attributed to the mother. Each parent or caregiver's past and potential future performance of parenting responsibilities. Again, I think that factor favors the mother. Mr. Butler had perhaps a good relationship and had been involved until he hit the last couple of years where it seems to have gone downhill pretty significantly. Refusal to attend a court-ordered parent education seminar. I don't have any evidence that either of them have completed, or both of them must complete it within 60 days, I think, under the parenting plan. They'll have to complete that and file notice of completion with the court. Disposition of each parent to provide the child with food, clothing, medical care. Mrs. Butler has been the primary person to do that. Mr. Butler has not been supporting the child since he left. And as a result of that, I find that favors the mother. Again, paragraph number 5, which parent has been the primary caregiver, found that to be in the favor of the mother. Love, affection, emotional ties existing between each parent and the child, I found that to be equal. I know that Mr. Butler loves his child, but under the circumstances, clearly his behavior and the things that he's been engaging in are the very reason that he finds himself separated from the child at this point. The emotional needs and developmental level of the child's been exposed to a lot of abuse in the family. You may not think that a child of this age would retain those things, or that it would impact them, but it clearly, in my opinion, creates memories for this child that will bear with it probably most of its life. The emotional needs and developmental life of the child favors the mother. Moral, physical, and emotional fitness of the parent. I have concerns, obviously, about Mrs. Butler staying in a situation or reuniting with Mr. Butler after some of the physical violence and things that have occurred. But that's a common thing, unfortunately, in domestic violence cases. It's not unusual to have someone who's been a victim of a domestic violence case who would take back their abuser or submit to their abuser again over and over and over again without trying to get out, because they have reasons. They have logical reasons that they think justify them trying to overcome or think they can fix the situation. In any event, I do find that this favors the mother, because clearly both in the history that has been testified to and the criminal cases that are pending and the court's observations of Mr. Butler are that this factor favors the mother. Child's interaction in a relationship with siblings, obviously I think there's been a good relationship between this child and the other children that Mr. Butler has, and I would like to see that continue. The importance of continuity in the child's life favors the mother, clearly. Evidence of physical or emotional abuse to the child or the other parent, clearly that favors the mother, because there is verified and absolute proof of the physical abuse of Mrs. Butler by Mr. Butler. Character and behavior of any other person residing in the home, I don't have any other information about that. And as a result of that, I don't find any of the other factors that really weigh on my decision. So based on all of those, I found that those factors favor designating Mrs. Butler as the primary residential parent. So where are we then regarding his visitation? I know that there was a schedule that was in place before. However, I'm very concerned because I do this on a regular basis. Mr. Butler has his own probation for 2 years by his own testimony. By his own testimony, he has a pending violation of probation. That pending violation of probation might very well return him to, or send him to prison for 2 years, or at least to jail for some period of time. And as a result of that, I am not in a position where I am comfortable with awarding him unsupervised visitation. In my opinion, I understand what he says about the situation, but it is, in my opinion, my job is to protect the best interests of the minor child. So I'm going to order that there be supervised visitation. He does not have to exercise it at the Eden if both parties can agree on an alternate supervisor, but it will be exercised under the supervision of another person. Miss Brady Wilkerson, you had indicated that there needed to be an adjustment because she was relocating. Is that correct?
Travel. So really,
well, my inclination would be that we do it every other weekend, and we do it from Saturday at 9 o'clock to 5 o'clock and Sunday at 9 o'clock to 5 o'clock. We'll have 2 full days with the children every other weekend, just not have overnight visitation at the moment. This schedule will stay in place until after, it'll be subject to review after Mr. Butler's criminal cases are resolved. But what I'm telling you, Mr. Butler, is this is right now being in supervised, continued supervision, because you have pending criminal charges that could very easily upend your entire life. Once that has been resolved, you are free to apply to this court, and it doesn't require material change of circumstances. I am putting that in this order that allows you to come back to court for a review and possible revision of your visitation with the children once you get your criminal stuff worked out. Do you understand that? Now, obviously, at that point, you're probably going to be subject to drug testing again, and the probation department may be doing that to you anyway. But I'm giving you an opportunity to try to modify this and go back to something else once your criminal charges are resolved. At this point in time, we'll calculate his child support based on her income of $6,000 a month, which is testified to. And you've asked to impute income to him of $25 an hour. I do not find that right now that's verifiable, but the child support guidelines do provide for imputing income. I think for a male, it's $39,000 a year. So if just check the child support guidelines, I will impute it as, I think it shows you how long it's been since I had to do it. But anyway, it'll be imputed on that basis rather than the $25 an hour. And again, that's subject to review once he's fully employed. He'll be given every other weekend as a credit for days. So I'm going to recommend an order in this that the parent parties, I know there cannot be direct one-on-one communication, but there's this parenting app that's out there that they can utilize. She can make him aware of the children. They can communicate through that. And that, in this court's opinion, will not constitute a violation of the order, no contact order. Ms. Brady is familiar with that. She can help you with that. As I said, this will be subject to a review and possible modification after you get your criminal stuff worked out. Now, how that happens between now and then depends on you. You've not had very good luck in getting yourself straightened out to stay away from getting arrested. And if you get arrested on something else, then that's going to make a difference as far as this court is concerned, what happens in the future. But that is the order regarding the she'll maintain the medical insurance and be entitled to a credit on the calculation for medical insurance. There is a retroactive child support order that would have to be in place from the date of filing of the divorce until it goes down. And that'll have to be calculated. Moving then to the property division. That's part of the requirements of the child support guidelines. So yes, it will be included. Going to property division, the house, I think both parties were in agreement the house is going to have to be sold. So as a result, we'll sell the house. I'm going to order that the proceeds after payment of all of the debts be divided equally. However, any request for attorney's fees that Mrs. Butler has will have to be deducted from the proceeds that Mr. Butler would otherwise receive for his share of that. I declined to order him to reimburse you for the payments you've made for the house. I know you were asking for $11,000 for his half of the house payments. You were living in the house for one thing, but I'm also going to offset your claim against his claim for your portion of your 401k proceeds. You'll be awarded those 401k proceeds, and that will offset any claim you have for him having to reimburse you for house payments. Each of them will be awarded the vehicles in their possession and be responsible for any debt on them. Each of them will pay the credit card debts in their name. She'll be awarded all the household goods, furniture, and furnishings that are located within the house. Anything he's acquired since the separation in the way of household goods, furniture, or furnishings that he's had to acquire, he'll be awarded all of that. I'm going to order that he be awarded his other children's clothes, toys, etc., personal items that those children have. He'll be awarded the sports equipment that he had mentioned that belongs to him. I'm also awarding him the toolboxes and tools and car lift. The reason I'm doing that is because obviously I'd like for him to get back to work as a diesel mechanic, and that needs to be done. He needs tools to be able to do that, my understanding is at least. Ms. Brady, you may submit your claim for attorney's fees for this court for review. Clearly, the law would allow that to be awarded, but as I said, it will have to be offset against the interest he has in the house. Mrs. Butler will be authorized to, on her sole authority, have the house listed with a realtor and go ahead and try to get it sold. She'll be able to negotiate all of that, but that will be subject to the court approval for the sale of the house. As the judgment of the court in this case, costs are taxed to Mr. Butler. Please, that I don't want her to sell the house for next to nothing. I want, when she gets this offer to list the house and she needs to list it for the price recommended by the realtor. And then if you get an offer that's less than that, then she just needs to come back in front of any of the judges to get an approval of that with notice to Mr. Butler.
Then also, Your Honor, one more thing for the record is that the countersuit filed by Mr. Butler would be dismissed.
It is dismissed.
Thank you, Your Honor.
Well, it's up to you as to how the future goes for you and your child. Hope that you'll make sure that you successfully defend this probation violation hearing, and you can come back down the road and try to get your residential time reinstated.
I thought I did my stuff on the house.
Miss Brady you'll have to get in touch with Miss Brady and arrange that, since you'll have to right. It'll have to be done with probably a civil standby by law enforcement. All right, Miss Roberts, did you and Miss Fordyce work out on the Ham case? Did you work out?
She was out. I think we all virtually everything we speak about a listing of the house. Here I have copies. You want a specific date, I think that's going to be done. So we be having it, and I don't know if we've got another confession to do to take that.
Yeah. All right, let's take it up. This would be Matthew Quentin Smith versus Elizabeth Carroll E. Smith.